Right, so we're on the record in docket 24-00104. This is Mr. 24-00104. That's people of the state of Michigan versus Darian Ray. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Nickel.
And Assistant Public Defender Scott Nickel on behalf of Mr. Ray.
This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. So this matter, as if the court will recall, has been adjourned a couple times for Mr. Ray to get counsel. It's my understanding that he now qualifies for the Public Defender's Office. However, we recently learned that there is a conflict with the Public Defender's Office and he needs conflict counsel. Additionally, it's my understanding that Mr. Ray is currently in the hospital. So I believe this will be a request for another adjournment.
Okay. Mr. Nickel, any record you want to make?
Both of those things are true, Your Honor, and just so the court's aware, we were able to get in touch with Mr. Ray this morning. He's trying to get a nurse or someone to get him some sort of documentation so he can provide it to the court just to verify that he is in fact in the hospital. And the conflict is not with this case, but it is with another case he has in 55th. And my office has decided to conflict out both cases, as the expectation is any resolution will be a global one.
All right, so request for adjournment, there's a seeking conflict counsel at this point.
Correct, and that request has already gone out. We're just waiting for someone to accept it.
I'm going to indicate he is in the hospital and should provide some documentation. But it appears that we'll adjourn for conflict counsel. Is this okay? So this is the same Mr. Ray that we had a kind of hearing on, or at least we met with the understanding that he really needed to get counsel on this. Okay. All right. So we'll adjourn for conflict counsel to be appointed for global resolution purposes. And the date is. I would, for conflict counsel, about 3 or 4 weeks, I would think.
I would think that would be appropriate.
April 12th at 9.
April 12th at 9 o'clock. Mr. Nickel, make sure that pursuant to the notes on the file that conflict counsel knows that any medical documentation for missing today's date should be presented to the prosecutor. So we know, the whereabouts of his appearance today. I'm assuming he's in the hospital. That seems that seems to be consistent, but we'll just make sure.
Absolutely.
All right. Anything else for the record? 24-00104. Ms. Wilson.
Not from the people.
Mr. Nickel.
No, Your Honor.
All right. Thank you. Thank you.
And then I believe we're ready on Mr. Shakur. That's a sentencing.
So we're on the record in docket 23-3791. That is people of the state of Michigan versus Elijah Shakur. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Elijah Shakur, who is present standing to my right.
Sir, you are Elijah James Shakur, is that correct? Thank you. This is the time set for a sentencing in the matter. First off, Ms. Wilson, is there any restitution in the file?
There is not, Your Honor.
All right, thank you. Ms. Schroeder, have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor.
Any additions, deletions, or corrections?
There is a deletion in 2 spots from the report, or actually 3 spots, pardon me. On page 1, under defendant's statement, last sentence, I have spoken, Mr. Shakur, regarding this statement that I indicated that he told probation that I told him to lie to the court so he could go home. He indicated to me that's not what he said, and I would like that stricken because I'm sure the court's aware I did not do that.
I will indicate for that it is contested and stricken.
Right. And then 2 times on subsequent page 2, about spinning a story about his attorney, telling him to, I would like that stricken as well, same reason.
Okay.
And then down under overall impression, and there's a 3rd sentence making the same, essentially the same statement. He and I have discussed that at length. He does not know exactly how that came to be in the report, but he denies making that statement, and I certainly deny making any such statement.
All right. With that understanding, those 3 are contested and stricken pursuant to the request. Anything else under additions, deletions, or corrections?
Nothing further, thank you.
Allocution.
I'm sorry, Your Honor, I think I just lost the hearing. Anyway, thank you, Your Honor. I've spoken and gotten to know Mr. Shakur over the time period of his case here. What I will tell you is that Mr. Shakur took a lot of initiative after entering his guilty plea. There's reference in the PSI to him taking programming, but no evidence of it yet. In the audience today is Ms. Heather Dahl, DAHL, from Crystal Ray. I've spoken with her, confirmed with her that she has been working for approximately 3 to going on 4 weeks with Mr. Shakur in their anger management programming over there. It's a 10-week course. She indicated to me that he has been active and engaged in the programming, and that's one of the reasons she was pleased enough to come over here today. They don't have reports finished quite yet regarding a substance abuse assessment that was completed, but she said they are working on finishing writing that up presently, and it should be available within the next few days. I hope, to be able to provide a copy of probation, but she indicated he did complete one, and they're just finishing doing the final drafting of that assessment. So I believe he's taken a very proactive approach on this matter. From my understanding, he has not had any violations as to the tether that he currently is on. He is, oh yes, yes, anger management, we already discussed, yes, but he is working his way through that program, that 10-week program, like I indicated. And he, I think he is taking the matter seriously. He may disagree with some of the characterizations from probation as well as from the police report from the original case. However, he does not disagree with the idea that this should not have gotten to this point. He should not be here today. This could have been handled differently. And he is taking steps to make sure that he does not have a repeat. He's gotten, I think he can agree, too old for this, and he's got so much to lose right now. Because he is working on employment. He's working with Crystal Ray on housing. He's got a brother that's providing him some supports while he is out of the house where he was living, which is where the victim lives, and his wife. He would like to be able to go back home. I know he also understands, though, that the court is unlikely probably to do that today based on some statements in this PSI. But he still very much would like to at some point go home and potentially work on couples counseling once things have settled down further. He has some significant health issues, and he may make a request in the future to have the tether at least temporarily removed, because he may have to have surgery on his heart. There's apparently some heart issues, congestive heart failure. And all that being said, Your Honor, I'd ask you to give him the opportunity to have probation. I would ask the court to consider a lesser term than 18 months at this point, given that he has taken some very proactive approaches and that he does have a support person in the from his programming here within the audience today for him, and that any testing, if ordered, be able to go through reality counseling, as that apparently that location is very close to where he's currently engaged in counseling, as opposed to Adam or somewhere of that nature.
Thank you. Is there anything you'd like to say to the court, Mr. Shakur, before the court passes sentence?
I've just been staying in hotel rooms for like months, and costs like $2,000 a month to stay in a hotel room. Like kind of running short on money. Like I've taken out credit cards and done everything I could to, keep a roof over my head. I quit my last job because it was at a bar, and I quit that job like shortly after, and also because of my heart condition. So,
Well, all right, thank you, Mr. Shakur. My decision today is whether you are a person who will benefit from programming today. And you've been programmed before, and you've been on probation twice and on parole before. And now we're here on a domestic 1 year second. And the pre-sentence has to be considered one of the worst I've read, okay? You threw everybody under the bus and took no responsibility, okay? You threw your attorney under the bus, you threw the victim under the bus, you threw everybody under the bus, and then you said, wasn't my fault. And if I remember correctly, the first sentence you said to the police was, arrest me, I beat her ass. Okay. I don't think you're a good candidate for probation today. I really don't. I think based on your criminal history that I've read, and I'll read it out loud here, I think I would be doing a disservice to put you on probation, not only to you, but to the rest of the community. And I was just looking at it to see, to remind myself of some of the items that you've already been to court on. In 2015, you have a felony assault by strangulation, in which you went to prison, a felonious assault, a misdemeanor domestic violence, a felony assault strangulation, found guilty by jury. I have an aggravated stalking that you pled guilty to in 2015, a felony stalking out of 2015. Those are both out of 30th Circuit Court. And then domestic violence out of 2002.
sir,
I don't think you're a person for programming, all right?
I will do it, sir. I'm trying.
I know you will do it. I know you will do it. I'm not going to allow you to do it today. All right. You're going to jail today. I think the community is a safer place for you in jail. The only thing keeping me from not giving you the full 1 year is the victim impact statement, which I indicated here. The victim impact statement indicated that I should mitigate your activity today. Other than that, the request, because of your failure to take any accountability and to throw everybody under the bus, was a term of incarceration. That was a request by the probation agent, who's a person who's supposed to work with you, right? That's a person who's supposed to work with you. Now, the victim impact statement indicated that although they were hit and they were beat up, there was that you should not be sent to jail today. That was the victim impact statement. I disagree with that. All right. So I'm going to sentence you on this case.
Your Honor, can I make one statement for the record?
You may.
In the same report to the PSI, Your Honor, it does indicate that probation would work with him if he shows some self-reflection on his actions, and that they would put him on probation. He's made significant changes, and he's made self-reflection by going to treatment of his own volition. I would still ask the court to consider probation.
I understand the argument, counsel. I simply do not believe that that programming is necessary for this individual today. I look at the PSI. I believe that he has thrown everybody under the bus but himself in the PSI, understanding that the PSI recommends that he take some accountability. I've seen none. I've seen a tremendous accountability on behalf of counsel. I've seen no accountability on behalf of the defendant. And so, but with this type of criminal record, I believe that Mr. Shakur has has found his own path today. Okay, has found his own path in regard to the DV second. That the DV second, I will indicate, and then programming, extensive programming over the past 10 years. So based on the finding of guilt from the plea, and I believe the plea date on this was January 25th. There was no contest. I'm going to waive fines and costs. Going to waive the crime victims' rights fee and the state fee. The defendant is to serve incarcerated 180 days in jail, beginning today, March 18th. Actually, today's March 21st. I don't know, he would get whatever credits available. They didn't do a credit list on the pre-sentence.
It looks like it's 3 days, you're on
Okay.
the top.
So 3 days credit. Previously served. And that's the end of the sentence. I'm not going to order anything else. Fines and costs to be waived. This will be administratively closed pursuant to the order of the court. The defendant spent 180 days in jail. Anything else for the record in docket 2303-791, Ms. Wilson?
Nothing, people.
Ms. Schroeder.
No, Your Honor.
All right. Mr. Shakur, good luck to you. I didn't write anything. I didn't write the Right.
Trying desperately to find my hearing.
And then I'll sign.
Yeah.
The more replacement.
You already signed it on the file, so
Okay.
since it wasn't too messy, I just left.
All
it.
right,
Probation doesn't have to take them over.
All right.
Criminals are just gonna.
Oh, there it is. Yeah, so.
How did it get all the way into there?
Any luck, Ms. Schroeder?
I actually did find it. It got under the lectern somehow.
All right.
Thank you.
It's gonna be in the most difficult place to find.
It's gonna be also the most irrational place. Like, how did it even manage to find it in this?
And then I think we're ready on Tanika Williams.
I think it's fairly, if I remember. I just skipped this.
Yeah, I think we just go there. Yeah, I think you just, I can just give it to them.
Okay, thank you.
Hey, Wendy, can I give you the plea packet for Pete?
Please pack it, or am I still putting it together?
No, it should be the complete packet
Okay,
from our
perfect.
side. Yeah.
Perfect, thank you. We also have.
Yeah, okay. Let's go on Williams.
Good morning, Your Honor.
Good morning, Mr. Feigelson. How are you?
Well, how was yourself?
I'm pretty good.
He's just flying everywhere today.
Got his fingerprints done.
What are we going on next, Ms. Wilson?
Tanika Williams.
Ms. Williams?
And there's paper.
Judge, who's on call for Fitch Parade this week, you know, this weekend?
I believe it's no more, but.
I
let
think
me
it's the
check.
magistrate.
Good for me.
Yeah. Are you on?
I am on call.
You're on arraignments?
Yes.
I can check just a moment.
You may, Mr. Milks.
Thank you.
Thank you.
No, it's actually.
All right, so we're on the record in docket 24-00598. That is people of the state of Michigan versus Tanika Williams. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Mills.
Thank you, Your Honor. Stephen Milks on behalf of Ms. Williams. Ms. Williams is present and staying to my right at this time.
And ma'am, you are Tanika Williams, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to an added count 4 of misdemeanor stalking with a killabrew to no upfront jail and restitution in the amount of $315.
Added count 4 of misdemeanor stalking, that's 1 year.
Mhm.
One year. Is that 1 year and or 500?
5 and or 1,000, sorry.
1 year. And what's the PAC code for that?
750.411H.
Right. And with a plead and successful sentencing to count 4, the counts 1 through 3 are to be dismissed.
Correct.
And then there's a killabrew of no upfront jail.
Correct.
And restitution in the amount of.
$315.
Right, so I'll restate that for the record. It's an added count 4 of misdemeanor stalking. That's punishable by 1 year and or $1,000 pursuant to 750.411H. With a successful plea to that, to the count 4, counts 1 through 3 will be dismissed. There's a killabrew of no upfront jail and restitution in the amount of $315. Of course, this will probably most likely be referred to probation. Is that your understanding, Mr. Milks?
Yes, Your Honor, that is a complete and accurate representation.
All right, and that's your understanding, Ms. Williams? All right. May I inquire of your client of their advice of rights? And for the record, you did indicate, sign an advice of rights indicating 1 through 12, and you went over this with your attorney. Is that correct, Ms. Williams? All right. So I'll just go over the highlights of that. You understand you have the right to a jury trial in this matter, correct?
Yes, Your Honor.
You understand that you have the right to be represented by counsel, and that's Mr. Milks.
Yes.
And he would be present to cross-examine any witnesses or contest any charges brought by the people against you.
Yes, Your Honor.
And you have the right to remain silent. You don't have to testify if you choose not to testify. Do you understand that? Okay. All right. And indicate, and I'll put in the file that the advice of rights and plea information was signed and is attached to the file by Ms. Williams. And you signed that, is that correct, ma'am?
Yes, Your Honor.
All right. If your plea is accepted, you give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to any trial because you won't be having a trial today. You'll be pleading guilty instead. Is it your intent today to plead guilty to count 4, which is the misdemeanor stalking?
Yes, Your Honor.
All right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth on a penalty of perjury?
Yes, Your Honor.
All right. I'll bring your attention back to, we'll do the, Ms. Wilson, the dates for the aggravated stalking.
Yes,
The dates
that
for
is
the
correct, Your
misdemeanor.
Honor.
All right. So on or about September 27th, 2023 to December 27th, 2023 at the offense location of 2303 East Jolly Road, City of Lansing, Ingham County. Were you present on those dates between September and December of 2023 in the City of Lansing on East Jolly Road?
Yes, Your Honor.
All right. And at that time, did you have contact with an Erstine Vaughn concerning this stalking case?
Yes, Your Honor.
Mr. Mills?
Your Honor, I'm sorry, it's a confusing fact pattern.
Okay,
Would it be okay if I inquired?
absolutely.
I thank you, Your Honor, I do appreciate it. Okay, so specifically regarding Ms. Vaughn, now you didn't see her in person that day, is that
No.
right? But you were at her apartment building, is that correct?
Correct.
And between those dates, there was a time that you ended up breaking her car window, is that correct?
Correct.
And you would agree that this is something done to intimidate or frighten her, is that right?
Correct.
And you would also agree that within this time period, you did make several phone calls to her, is that correct? And you would agree that the nature of these phone calls was to intimidate or frighten her, is that fair?
Correct.
Okay. And you would also agree that a reasonable person could also find this intimidating and or frightening, is that right? Okay, if that would satisfy your own.
Thank you. Anything towards the factual basis, Ms. Wilson?
No, the people are
All
satisfied.
right,
with
I
that.
find the factual basis to be knowing, voluntarily, and accurately made. in regards to the misdemeanor stalking. Miss Williams, I forgot to indicate, the attorneys have agreed that you receive no jail up front. Okay, it's Killebrew to no jail. This is going to go to probation, and then I'm going to look at this and review it. If I were not to give you no jail up front, you'd have the opportunity to withdraw your plea. Do you understand that, ma'am?
Correct.
Okay, so that's an agreement between the lawyers. I may follow that. I want to read the probation report, but if I don't follow it, you'd have the opportunity to review to withdraw your plea. Okay, so we will send this to probation for a pre-sentence report. So that'll be on the 5th floor. So go down and find, what they're going to do is ask you a bunch of questions, get a report, just be as candid as you can with them, all right? Be as candid as possible, and they'll prepare a report, and then we'll look at what options are available to us at sentencing, okay? All right. Sentencing date of?
May 23rd at 8:30.
May 23rd at 8:30. All right, you'll get notice from my court officer, maybe. So we've set the sentencing for May 23rd at 8:30. That's when the report will be done for me, and then we'll see what's available to us. All right, ma'am? All right. Anything else for the record in 24-00598, Ms. Wilson?
I have a restitution form. Would you like me to approach?
Absolutely.
Sure, would you mind handing me? Thank you, Mr.
Right.
And then the other one goes to
Me.
Anything else for the record in 24-00598, Mr. Milks?
Briefly, Your Honor, if we may address bond, particularly
Okay.
just the tether requirement here.
All right, you may proceed.
Thank you, Your Honor. Your Honor, at this time, we are requesting removal of the tether, and there's good reason here, Your Honor. My client is a CATA bus driver. She did bring her schedule, and just so the court would be able to see that. But her route does take her all around Lansing, at times even towards the exclusion zone. She works 10-hour plus days, 10 hours essentially the week, and charging can prove very difficult in order for her to maintain her route. She's a single mother. She's trying to maintain her job, support her children, as well as making sure she's here to pay restitution. Now, I will say, Your Honor, she actually is prepared to advance the full amount of restitution. I don't think she can pay that just yet, just because the order hasn't entered, but she is ready and prepared for that. Further from that, Your Honor, there's been no contact incidents between the two individuals here. She has no desire to see her. There's still a PPO in effect, Your Honor. So I think any concerns the court may have would be abated by those securities that are in place. In truth, Your Honor, this was a moment of lapse in judgment that just revolved around one man. That's no longer an issue here. And I think under these parameters, Your Honor, this would warrant a situation where the tether be removed in order to help her move forward, make sure that she's still well employed. Thank you.
Thank you, Ms. Wilson.
Thank you, Your Honor. Just in speaking with the victim yesterday, it's my understanding that she has moved to a new address that I believe Ms. Williams is not aware of. So I think that one, the tether right now is not necessarily doing any good with the current address. And I don't know that we want to necessarily disclose that address.
Right.
So I think removing the tether is not necessarily a bad option right now.
Based on the representations of counsel and ma'am, and partly because of your work schedule, the driving schedule, I'm going to modify a bound to remove the tether at this point in time.
Thank you so much.
I'll remove the tether. Now, Ms. Williams, you could do nothing worse in this whole situation
I'm not.
than have contact with Ms. Bond.
I'm not.
You're on probation. I mean, that would be the worst thing you could do. It's a PA 53 violation. Miss Wilson's going to come in and ask for jail time, and then that'll be worse than the GPS because a violation of no contact order would mean that I'm going to put you in the jail pending sentencing, and we don't want any of that to happen, right? All right. I do find good cause to remove the bond modification based on some of the representations of counsel. So go right to the 5th floor and see the probation officer. That's who you'll be working with through this process. that's also going to be a person who's going to do the recommendation to me. So you want to make sure that they're happy, okay?
Could I go put money in a meter, then go?
Absolutely,
Thank you.
absolutely. All right, so I've modified bond to remove the tether. And I think we contact the tether company. Yeah. Anything else for the record in 24-00598, Ms. Wilson,
Not from the people.
Mr. Mills?
No, not from the fence.
All right, we'll see you on the sentencing date, May 23rd, Ms. Williams. All right,
Thank you so
ma'am?
much,
Okay.
Judge.
Your Honor, may I approach a prosecutor?
Yes.
Mr. Shakur, and I believe Ms. Wilson has what to say. He actually had a kill group for no upfront jail. He's not getting the opportunity to withdraw.
All right, so let's get him up here.
Okay, yep.
Thank you.
So
I don't think she can ID.
so Nathan, you'll probably have to go get Mr. Shakur.
Yeah.
All right.
Do we want to put Mr. Connolly on the record while we're waiting for Mr.
Sure.
Shakur to come up?
That's the 1:30 this afternoon. That's somewhere in the.
Judge, I don't see,
So,
I don't see the guilt. You may, unless I'm not reading it right, which is also an entire possibility. Are you okay with that?
Yeah.
Philip,
I'm
we know
fine,
it
yeah.
comes down.
It is in there.
Yeah, and I've talked to them, they're all they did with it too. so.
That.
Okay. I haven't checked yet.
Ma'am, what's your name?
I am Amanda Love.
Mr. Conley's due Laura. Otherwise known to us as Mr. Conley's due Laura. Well, Ms. Love, I don't think we've had the pleasure of meeting.
We have met one time at the Italian-American dinner,
Have we really?
but I think I remembered you because you were with Julie O'Neill and she was sitting at my table.
With, from Eaton County.
Mhm.
Yeah, I've known Judge O'Neill for a long time. What's that?
Oh, I was reminding Ms. Holden what we were doing.
Right, so
I did remember.
we're on the 1:30 count.
Okay,
Correct,
we're
yes.
cruising to that. Okay,
Yeah.
thank you, Judge.
All right, so we're on the record in docket 23-01237. That is the People's State of Michigan versus Benjamin Conley. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Love.
Good morning, I'm Amanda Love. I represent the defendant, Benjamin Connolly. He is currently not here as he was moved to a different facility and the writ was not valid anymore.
Correct. That's my understanding that that this was conflict counsel various times. And then Ms. Love, you're actually indicated by name by the public defender who was having this was a 5 co-defendant case, as you know, so there was a lot of conflict counsel on this. It appears that Mr. Conley had moved to Department of Corrections placement, and therefore the writ that we sent for him was kind of useless. So at this time, and I believe Mr. Conley waived his 21-day rule back in September when this all started, when we were trying to get conflict counsel. So request for adjournment today, I assume.
Correct.
Yeah, we
Right.
were told that it could be moved to April 11th at 2, and me and Ms. Wilson confirmed that we both have that date open.
All right, so we'll adjourn preliminary examination to April 11th at 2 o'clock. And of course, we will writ out the defendant for preliminary examination. Anything else for the record in docket 23-01237, Ms. Wilson?
Not from the people.
Ms. Lowe,
I just want to put on the record that he is currently at Parnell,
Parnell.
which is in Jackson. Even when you run his Otis record, it still says RGC. So he absolutely is at Parnell, and that's where the writ would need to go.
All right, so Parnell DOC in Jackson.
Correct.
And if that changes before April 11th,
Let
we'll
us
try to
know.
make the court
Let us
apprised.
know. It seems like anything we do on this file
Yes.
it prolongs it in some way. But this is a unique file in that there were so many co-defendants in the original prelim. Okay, anything else for the record in 23-01237, Ms. Wilson?
Not from the people.
Ms. Love.
not from the defense.
All right, thank you. That's all set.
Thank you.
It's nice to meet you, Ms. Love.
Thank you, you too.
And then if Your Honor, if I could have a moment to pop out real quick.
Absolutely.
Thank you.
All right, Ms. Wilson, what case is next?
Mr. Marquise Demeyers.
Myers. All right, so we're on the record in docket 23-02832. That's people of the state of Michigan versus Marquise Demeyers. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Feigelson.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Feigelson on behalf of Mr. Demeyers, who's standing to my right.
And sir, you are Marcus Demeyers, is that correct?
Marquise Demeyers, yes.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. The people are prepared to start the exam today. We have an officer here. We have had victim contact in the past, and while it was reluctant, they did say that they were going to comply. However, we've lost contact. So we would be requesting a continuance after starting today. We do have a detective working on getting back in contact.
Thank you. So you are prepared to put on a witness today?
That is correct.
Mr. Feigelson.
Judge, I'd ask for dismissal today. This is the third time we've been here. They're not here today. We're not even sure if we adjourn this, they're gonna re-come. They should have done this ahead of time, Your Honor, coupled with, I'm not even sure if they start with the officer, if she's gonna be able to get anything in to make it substance enough for bind over, even in the event that the alleged victims in this case don't appear in a couple of weeks. I'd ask for dismissal today. I'm aware it is without prejudice. They could just refile when they have all their ducks in a row at this point, and they've been given plenty of opportunity to get everybody here. They're not here. I'm asking for dismissal today.
All right, thank you. I will indicate the history of the case. February 16th was a motion to withdraw from the attorney that was granted. Mr. Feigelson was appointed on March 1st. There was a adjourn, and the waiver of the 21-day rule was waived. It was adjourned for discovery purposes, essentially switching attorneys. So we're set today for March 21st. People indicate they're prepared to start the examination, and so we'll start the examination. Ms. Wilson, are there any preliminary matters to come to the court's attention before we get started?
I would just add for the record that at that first date, the complaining witness was prepared to be here. However, they were called off because of the motion to withdraw. So it's not like there has been no attempts. I just wanted to put that in.
All right, thank you. There'll be a motion for sequestration concerning any witnesses. Both counsel understand the case, know the case better than the court. So bring it to my attention if anybody walks in or is a part of a viewing testimony that they shouldn't because of potential trial work in the future. With that understanding, anything to come to the court's attention, Ms. Wilson?
Not from the people.
Mr. Feigelson?
Nothing else from the fence, but I want to make sure it's
All right.
good enough for me, Judge.
All right, thank you. Just bring it to my attention. We'll make sure that the witnesses are sequestered. Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people call Officer Melinda Hutchings.
Officer Hutchings, if you'll come up here, right in front of me, if you'll state your first name and last name and spell them both for the record.
Melinda Hutchings, Melinda Hutchings.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
Yes.
All right, now go and have a seat. You'll want to talk into the microphone. That's for recording purposes for the court recorder. So please project to the back of the room. And Ms. Wilson, you may proceed when you're ready.
Thank you, Your Honor. Officer Hutchings, where do you work?
Lansing Police Department.
And how long have you worked there?
Coming up on 5 years.
What are your general duties?
I am a road patrol officer.
Were you working as a police officer on August 8th of 2023?
Yes, I was.
How were you dressed?
In my patrol uniform.
And does that have some kind of police designation on it?
Yes.
Okay. Now, when you were working on that August 8th date, were you dispatched to 1300 Georgetown?
Yes.
Is that in Lansing?
Yes.
To the best of your knowledge, Ingham County?
Yes.
Michigan?
Yes.
And why were you dispatched on that day?
I was dispatched to an unknown trouble. The caller advised she was choked by her father.
And when you arrived there, did you make contact with anyone?
I did.
Who did you make contact with?
I made contact with a Malia DeMyers.
Okay, and what was her relationship to the person who made the call, if you know?
I believe she was the person that made the call.
Okay, and what was Ms. DeMeyer's demeanor?
She was emotional.
And when you say emotional, can you describe that a little bit more?
I don't recall much further than that. She was
Okay.
emotional.
Did she say anything to you?
Objection hearsay, Your Honor. I don't think this is allowable under the domestic violence hearsay exception. That's what I think is where she's going, Your Honor.
Response?
I was going with an excited utterance, Your Honor. Or an existing mental or emotional state.
This, so that is, so you're not going under 768.27C.
That is correct.
You're going under an exception to the hearsay rule.
That is correct,
Explain to me how that doesn't violate confrontation.
because it's a hearsay exception.
It is a hearsay exception.
Right.
But confrontation is a constitutional issue, a Sixth Amendment issue. And so so the Constitution would keep it out, not the rules of evidence.
Doesn't apply to prevent.
Confrontation clause always applies, Your Honor.
So, I mean, so it's my understanding, so, and I'm basing this, the domestic violence victim statement under 768.27C applies to prelims and is a piercing of the confrontation clause. The confrontation clause would be that the actual impact of the victim. So the exceptions being used, excited utterance under present sense impression or under excited utterance, any one of the 23 exceptions would come in. But that's good for the federal, that's good for the Michigan rules of evidence, but it doesn't take care of the Sixth Amendment problem, which is right to confrontation.
Your Honor, may I assist?
You may assist.
Thank you, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people with Assistant Prosecuting Attorney Abigail Wilson. Your Honor, respectfully, Michigan case law states that the right to confrontation is a right at trial. It is not a right that is strictly held at preliminary examination.
Now, Mr. Feigelson.
Well, Your Honor, they're still getting it in through the confrontation clause. I think the proper exception is be the domestic violence, which they can't meet here. Your Honor.
But this I would have to be briefed. Okay, this would have to be briefed and arguments made concerning, because this is a problem with confrontation as I see it. The confrontation clause, the Sixth Amendment, as applied by the 14th Amendment to the states, would indicate that confrontation, as far as Ohio v. Clark, as far as the Crawford, People versus Crawford, and Michigan v. Bryant, would all indicate that exceptions are good for the rules of evidence, but they may not apply to confrontation. Michigan v. Bryant, I think Sotomayor indicated to go back to some of the rules in that Wayne County case, but there was nothing definitive. Now, if there's case law, Michigan case law, that would indicate that the exceptions from Michigan rules of evidence pierce the confrontation clause, I'd like to see that case law.
Your Honor, it's People versus only Michigan.
And that applied to domestic violence cases, Your Honor, which is what I'm citing this. They haven't been able to establish that yet either. I don't know if that they can. That's where I'm.
But yeah, if it only applies to 768.27C, then we have the same problem that we're piercing confrontation through the use of an exception, and that may or may not be available based on the case law. So I'd like each party to brief it before we go forward.
Okay, Your Honor.
Right? Yeah. So we'll reset the preliminary examination to look at if Michigan has allowed the confrontation clause to be pierced pursuant to 768.27C, in what way, and that would be the standard if there is a Michigan rule of evidence exception that is allowable at prelim, I will certainly hear the exception in relation to the to piercing confrontation clause. But that I'd have to have that briefed and have Mr. Feigelson at least respond to the brief, since this is a different approach to getting in hearsay statements that are become problematic under the confrontation clause. So so let me make that note. Okay. So the prelim was started and the officer called.
And Your Honor, I do have a few additional questions outside of that I could potentially ask, if you would want me to pursue that today.
Sure,
Or,
yeah,
okay.
yeah.
All
So
right.
let's go forward with what we can, and then we'll reset it for briefs due on the piercing of the confrontation clause through the exceptions.
Thank you, Your Honor. Now, Officer Hutchings, in your time with the caller, did you have occasion to observe any parts of her body?
Yes, I did.
What parts?
She had shorts on, I believe, so I could see her legs.
Okay, and did you observe anything of note on her legs?
Yes, I saw some markings.
What kind of markings?
I can't recall exactly.
Okay. Nothing further at this time, Your Honor.
Do you have any cross of the witness at this time, Mr. Feigelson, or would you choose to?
Just one or two briefly after
Okay,
that
and
last stuff.
we'll bring the witness back, Ms. Hutchings, for any hearsay argument concerning this. Ms. Hutchings is subject to subpoena, but if you want to,
I'm
the
good.
questioner outside of that.
We'll do it next week.
Okay.
Or not,
All right.
next time we have to work.
All right, so let's reset the prelim. This will be adjourned. And we should put it out maybe 2 weeks for the brief and then a week for the response. So maybe over 3 weeks out.
That sounds appropriate.
Yeah. So
Thank you, Your Honor.
let's do 30 days. April 18th at 1:30. So we'll do the It's the 21st. So let's have the prosecutor, we'll have a brief from the moving party due on April 4th. And you can make it as formal as you want, but just so I know what case you're relying on in regards to the piercing and the confrontation. And then any response will be due 1 week later on April 12th. And we'll do the prelim on April 18th. Anything else for the record in 23-02832? Ms. Hutchings, you are still under subpoena, okay, for that April 18th date. And then we'll revisit some of these hearsay statements that are outside the realm of 768.27C, or depending on what they put in the briefs. All right, ma'am? All right. Anything else for the record on 23-02832? Ms. Wilson.
Not from the people.
Mr. Ferguson.
Nothing further.
All right, thank you.
About bond, but it doesn't ease in until the early May, so.
All right.
That's futile.
All right. So I'll see you on the April 18th date.
All right, thank you.
All right. Thank you. Yeah, just to remind me that.
And I believe APH now on Newell.
Yes.
Oh, where did she go?
Oh, she's in the library over there. Do you want me to go get her?
I can grab her. I'll be right back, Judge.
Good morning, Judge.
Good morning.
Gather,
What's that?
should we gather for the Newell case?
Let's wait to see what's going on.
Oh, okay.
what case is being called. I think that's the case we're going on, but let's see what else she runs into out there. The cases.
Wait right there.
And we're going. So we can come up on Newell.
Have a good day, Judge. Thank you.
Thank you, Mr. Feigelson. So there's a Jessica Jalacia. Is she a part of the case at all?
I don't believe so. I don't recognize that
I'm
name.
gonna put in there in the waiting room
Okay.
since I don't know who that is. All right, so we're on the record in docket 24-00189. That is people of the state of Michigan versus Jonathan Newell. Will the parties please introduce themselves for the record from the people?
Good morning, Your Honor. Sage Castleman on behalf of the people.
Good morning, Your Honor. Lisa Kirsch-Satawa on behalf of Mr. Newell, who's present.
Thank you. And sir, you are Jonathan Newell, is that correct?
I am.
All right, thank you. This is time set for preliminary examination today. Ms. Castleman, how are we proceeding?
We are prepared to proceed, Your Honor. We do have just one witness today. I don't think there's any other witnesses in the courtroom today related to the case or persons for this case today.
All right. Ms. Satawa, is that a fair statement?
Yes, Your Honor.
All right.
The victim's therapist is present today and will be sick, as well as my advocate will be in the courtroom. I don't believe either of which would ever be a witness in this matter.
Your Honor, I believe that the therapist would be a witness in this matter, as the therapist was I'll call it the second disclosure person. It's not really clear if she was the first or the second, but
So
Was she interviewed as part of the investigation process?
I am
don't- so
I am
I
not
don't-
sure, but she
Yeah.
is definitely
a potential
a
witness.
potential witness.
I don't believe so, Your Honor. Pursuant to People versus Stanaway, her records would never be discoverable in this case. Just because mental anguish is a factor in this matter does not mean that the therapist would ever be a witness, that any of her records would be part of this case. It would be different if this was first disclosure 911 caller, or this person was interviewed as part of the case. She was not. I do not believe she is a witness, and I believe that this person should be able to be in the courtroom because it is a public courtroom, but more importantly as well, there's a public interest in having, both victims and defendants able to have their support persons in the courtroom.
Mrs. Towick, you obviously have an objection to the witness being present.
I do
Would you like to
because-
make a record?
Yes, Your Honor, I do, because that my client is charged under the incapacitated element. And she says that she's taking medications that make her sleepy for many different psychological conditions, and she's already disclosed that to the police. So she's pierced the privilege already, and she is a potential witness.
And if she may not be a potential witness for the people, but she's definitely a potential witness for the defense.
Absolutely.
And so, and Ms. Castleman, you may proceed.
So that is correct. In the same examination report, there are medications listed, and this is an incapacitated victim case and a case where the victim was sleeping. However, this is a therapist. She does not prescribe this person any medications. Yes, if her doctor was here, she could be a potential witness. Yes, if her psychiatrist was here, potential witness. Yes, if the SANE advocate was here, potential witness. Yes, SANE medical examiner, potential witness. A therapist, there is published case law on this, many, which I'm sure Your Honor is aware that these records are not.
I'm not concerned about the records.
But she is not a potential witness.
I'm not concerned about the records. What I'm
Anything she could testify to is privilege.
Thank you. I'm not concerned about the records. What I'm concerned about is her disclosure and the potential for impeachment. That's what and so she may not be your potential witness, but the defense is saying they may call her as an impeachment witness because there's inconsistencies concerning the disclosure.
But theoretically, anyone then could be a potential witness.
Anyone
Any
disclosed
person.
to.
Well, any person that this victim.
Not
was
every
talking
person,
to.
only those disclosed to. I couldn't be because she hasn't disclosed to me. Correct?
I understand that, but I'm
Okay.
saying that this victim may have talked to many people about what happened. This is not the first.
Then they all could be potential
But
witnesses.
she has a privilege. This is a therapist. There is a privilege here, a legal privilege that she cannot be asked about private information from a therapist session in a sexual assault case.
Yeah, but that's a waivable privilege, is it not?
Yes, but it must be
And it-
waived by the victim.
Correct.
She's not going to waive it.
All right, well, then it's a potential witness because that she is allowed to be impeached or to be asked questions. And that's a different issue. That's a different legal issues. Now, if you want to bring that to the court's attention, then we can brief this matter on that issue. But my understanding is that one witness cannot ask another witness or cannot view another witness's testimony. And since she's a potential witness, she'd be subject to sequestration.
I do not believe she is a potential witness. I can check with the victim on whether it's a make or break on whether she's going to be able to testify without the support. of the
At this time, I find her subject to the sequestration order.
Okay. Then give me 1 second, Your Honor.
All right.
And I will go discuss this with her. real quick.
Your Honor, may I approach on an unrelated matter?
Sure. I don't know about that, but thank you for saying so. It has its days just like any job. It's a good gig. Nice. I didn't want to be right. Proceed with the preliminary examination.
Yes, and I just want to clarify the record a little bit.
Okay.
So I talked to the victim and the second disclosure was actually to Jamie, who was her son's therapist. She actually didn't start seeing this therapist until months in. But I understand, you know, the court can make whatever ruling they wish, but I just wanted to clarify.
All right, thank you for that clarification. So counsel, both counsel know their case better than I do. If you see anybody who's a potential under sequestration violation, because we have an open courtroom and they walk in and out, please bring it to the court's attention, and I'll make sure that one witness does not observe another witness testify. With that understanding, Ms. Castleman, you may call your first witness.
All right, and I would just want to clarify that the therapist in question that has been sequestered from the courtroom is named Lauren Fry.
Okay, thank you.
I would be calling Jasmine Shuri.
Right, ma'am, if you could come up here. I'm gonna have to indicate your first name and last name for the record.
Jasmine Shirey,
Okay, spell them both.
JASMINESHIREY.
All right, raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right, thank you. You can have a seat in the witness chair. The microphone is for the court recorder so she can hear you. So please amplify as best you can. All right, ma'am?
Okay.
All right. Ms. Castleman, when you're ready.
All right. On October 16th of 2022, were you in a relationship or sorry, were you in, did you have any type of relationship with a Jonathan Newell?
Yes, we father, or we parent a child together.
You parent a child
Yes.
together? Okay. And were you in a romantic relationship on October 16th of 2022?
There was some physical contact that was consensual.
Okay, so there's some
Before,
physical
yeah.
contact that was consensual before,
Yes.
before that day.
Yes,
Was it around that day?
yes.
Okay. And how would you categorize your relationship with Jonathan Newell at this time?
We don't, no contact.
No, at the time of October 16th of 2022.
Co-parenting.
Can I, excuse me, Your Honor, can I just ask her to raise
Yeah.
her voice a little
Right.
bit?
Thank you.
And I'm gonna have you move the microphone towards you a little bit. It's right there on the corner. See, yeah, if you put it right closer to you, so it'll pick you up as you talk. You're talking down into it.
Okay.
All right, you may proceed, ma'am. Your last question was on the October 16th date
Yes.
and the
yes,
relationship between her and the defendant.
Yes. So what was your relationship with him on that date?
We were just, there was no relationship. We were just parenting.
Okay. Were you off and on in terms of
Yeah,
your romantic
like, we've been
relationship?
off and on since we met.
Okay. And when did you meet him?
Ooh, I wanna say 4 years prior.
Okay. And what is the name of the child you share together?
Kyler Clemens.
Okay. And was Jonathan Newell, did you spend time with him on October 16th of 2022? Where did you spend time together?
We were carving pumpkins. with the kids.
Okay. And whose idea was it to come over?
Mine.
Okay. And how did you propose that? Like what was supposed to happen that
He
day?
has never, that you just met as a child, and I figured that, you know, carving pumpkins with, you know, me and all the kids would be good for him and the baby, and
Okay. And how old was Kyler at this time?
he's 2.5.
Okay. Back in October of 2022?
Yeah, 2.5.
So he was beginning his relationship with your son?
Yeah.
Okay. And were you supposed to have romantic contact during this night?
No, because we had just previously broken up.
Okay.
I'm sorry, I really can't
Yeah.
hear
So
her.
we just previously broken up.
And so you had just previously broken up?
Yeah.
Did you have any conversations with Jonathan before he came over about, you know, having physical sexual contact?
No.
That night? Okay. And so did you guys end up carving pumpkins?
Yeah.
All right. And what happened later in the night?
we were on the couch.
Oh, and, sorry, finish that answer, I'm sorry.
We were on the couch in the living room, put on a movie for the kids and just kind of hanging out.
Okay,
While the kids lay down to go to bed.
and this is your house?
Yeah.
Where is that house located?
It was, it's the, on South Washington.
Okay,
Lansing, south side of Lansing.
starting with the number 6,
Yes, I think it's 6401.
and is that in Ingham County?
And, yeah. I
But that's
believe
in
it
the
would be-
city of Lansing?
Yeah.
Okay, and, who is there in the living room?
All 5 of the kids and I.
Okay, and you have one shared child, do you have other children?
I have 4 other children
Okay,
and 1 shared child with Jonathan.
okay, and, who was the oldest child that was there?
My twin girls,
Okay, and what other children were there?
my son Brock in it, and then my other son Adrian.
Okay, and how old are those kids?
Right
All of
now
the
or
four
back
kids?
then,
Back then in 2020.
8. Adrian would have been 4.5, 5, and then Brock would have been 5.5, 6.
So Kyler was the youngest?
Yes.
Okay, and, when did the kids end up going to sleep?
I want to say it's roughly 8 o'clock, 8:30ish.
Okay, and where did they sleep?
They all slept in the living room on the floor.
Did Mr. Newell sleep at the house that night?
No, he did not.
Okay, or, sorry, better question, did you, what was the plan in terms of how long Mr. Newell would stay at the house that night?
Yeah, I guess there really wasn't a plan.
Okay,
It wasn't really previously discussed.
and how long did he end up staying at your house?
He left my house roughly 10:30, 11 o'clock.
Okay, and, how was the night after the kids went to sleep?
There
Between you guys.
was foreplay before I went to bed. I took my meds and I sat on the couch and there was some foreplay, and then I fell asleep and I woke up with his penis inside.
And so what do you mean by the word foreplay?
His hands touching me.
Okay, by foreplay, was there any expectation that there would be more that would happen after that? Was there any conversation you guys had about him, doing things to you while you were sleeping?
No.
Okay, had you ever had that conversation with him?
No.
Okay, had that ever been something that you guys had agreed to do before?
No.
Okay, and, with that, so during that time, were you on any type of medication?
Yes.
Can you tell me how those medications affected your sleep?
I was on an anti-anxiety med.
What was that medication? I'm
I
sorry.
believe it was my Vistrol, and I was on 50 milligrams of that 4 times a day.
Mhm.
And then my Trileptal, and I believe I was on another antipsychotic at the time.
Okay,
I don't remember the name of that one. though.
and were you taking these medications as they were prescribed by a psychiatrist? Right, and, so how do those medications affect like your ability to recall this event?
Your Honor, I'm gonna object to the leading nature of the question.
Okay, objection leading response.
I don't believe it's leading. I think it's relevant for the court to understand whether she can remember what
I think
happened
you-
on the medication.
I think it's relevant. I don't know
I
that
can lay a
it's,
little foundation.
I agree, but I'm gonna have you rephrase the question because I don't know if she has the expertise
Okay,
to indicate that.
Yeah.
So I'll allow you to rephrase the objection sustained.
were you on these medications for a long time?
Yes.
And, while you were on these medications, could you remember what happened in your day-to-day life?
Yeah.
Did you have any trouble remembering things on these medications? Is that the same with what happened this night? In terms of, do you have any trouble remembering that night due to the effects on the medication?
No.
Of the medication? Okay. And, how does that medication affect your wakefulness?
I take my Vistrol, my anxiety med, and my other antipsychotic to help me sleep at night because I have a hard time sleeping, falling asleep.
Okay. How does it affect your ability to sleep?
I'm not supposed to wake up during it. After sleeping.
And You notice a difference between your sleep when you're on that medication versus not being on that medication? What's the difference?
I can't fall asleep.
Okay, what about waking up? You wake up easier or harder or something else?
It's harder for me to wake up
On the medication or
on the medication.
Okay.
On the medication, I wake up 4 to 5 times a night.
So does this medication allow you to sleep through the night?
Yeah.
Okay. And what was the first thing that you noticed when you woke up?
He was on top of me.
That was Mr. Newell? And how was he on top of you? Like, how was his body in relation
My
to your
leg
body?
was, I was on my side and my leg was twisted up and like pushed up. And then pants were down and my pants were down.
Had you fallen asleep in that location?
Yeah, I fell asleep
Okay, and where in the room were you?
on the couch.
On the couch? All right. And had you fallen asleep with clothing on? What kind of clothing?
Said yes.
I'm sorry, yes.
Yeah.
And-
T-shirt.
Did you have any underwear on?
Yeah.
Okay. And what did you notice? What did you feel at that time? Okay,
You.
you said confused?
Scared and confused.
And what did your body feel like?
Frozen.
And how was his body touching your body in any way when you woke up?
His penis was inside of me when I woke up.
Where was his penis inside?
In my vagina.
And did you have any, like, how did that feel in terms of his penis in your vagina?
I don't understand the question.
So was it, like, I mean, I guess what kind of feelings did you have in your body about, that going on?
I was scared and I was confused and I didn't know what was going on and I know that I didn't ask for it and it's not okay.
And
My kids were,
sorry, go ahead.
my kids were sleeping in the living room next to me and it's,
Was it light or dark in the living room when you woke up? Okay, it was dark.
TV was on.
And were you familiar, or sorry. So how were you positioned kind of when you woke up in terms of like, I guess, how was his body positioned? You said that your legs, okay. And was he facing you or a different way? Facing you?
Yeah.
Okay. And did you notice anything about your children when you woke up?
And they were still sleeping as far as I could tell.
Okay, could you see some things in the room even though it was dark?
Kind of, I put the pillow, I kind of moved around, I pretended like I was still sleeping when I woke up. Because I was so fight or flight and or fight or freeze. And I froze and I didn't want my kids to wake up with me freaking out.
So is
And
that,
I tried to focus on the TV and the couch and the pillow.
what were you concerned about if your kids were to wake up?
Seeing it, being confused, being scared. If I was to wake up, like freak out and wake them up, then that baby, so.
And do you recall talking to Officer Seth Osentoski back on October 18th of 2022 about what happened here? Okay, do you remember, do you recall telling him about the pillow on your face? And do you recall telling him about whether Mr. Newell had anything to do with the pillow on your face?
Yeah.
Okay, can you tell me about that?
He didn't, I did.
Okay, can you explain that a little bit?
When I woke up And I thought I didn't want him to know that I was up because I didn't want to wake the kids up, so I kind of made sure that I like was moving around, hoping that he would stop because, you know, maybe she's waking up and stop what I'm doing. And then I kind of had to move the pillow over my face a little bit so I could pay attention and not.
And how did that? So how did it? So how long was his penis inside of your vagina?
Let's say roughly 10, 15 minutes. Roughly.
All right. And were you looking at a clock during this time? Do you know for
No, I
sure?
don't know for sure.
Okay. And how did that penetration end?
He pulled my pants up. He pulled his pants up and he knelt down beside me and he said, "I'm sorry." And he got up and left.
Okay. And do you, during this interaction with Mr. Newell, did he have any other sexual contact with you? Like, did he touch your body in any other type of way?
No, other than to move me around.
Did he ever move your positioning on the couch? Can you tell me about that, please? And sorry, did you say yes or no to
Yes, I
that
said
question?
yes.
Okay, and can you tell me about that?
I was trying to move around so he would think that I was waking up, and then as I would kind of like move my position, he would move me back into a different position or the same position that I woke up in.
Okay. And do you recall whether he ever touched you with his mouth?
Your Honor, she has already testified that he did not touch her in any other way.
So objection to the form of the question
Yes.
as asked and answered. Response.
I don't believe that it was specifically asked or answered about his mouth specifically.
The question was asked, did he touch you in any other way? I'll allow it. Objections overruled. You may proceed. I did get, the initial answer was he did not touch me in any other way.
Yeah.
Did he touch you with his mouth in any type of way?
Kissed me on the right side, left side of the neck.
Okay.
Say that again, ma'am.
Kissed me on the left side of my neck. Right
Okay.
here.
And do you recall getting a SANE examination, like a medical examination after this incident on October 18th of 2022?
Next day.
All right, or the next day?
Yeah, it was the next day.
Okay, so on October 17th of 2022?
Yeah, I think so.
Or, and at that time, did you tell them about what happened?
Yeah.
And were you, when you told them about what happened, was that the best memory of what had happened at that
Yeah,
time?
it was the day after because I had taken my kids to my brother's house, like so he could watch them, so I could go in. And I was still wearing the same clothes and everything.
Do you recall telling them?
Objection, Your Honor. She's bolstering her own witness.
I'm not trying to bolster, I'm merely trying to refresh the witness's memory. It's been over 1.5 years since this is.
I don't think she said that she can't remember.
Well, I'm specifically going to ask her first, do you recall making such a
Ask her.
statement? And then,
Okay, so the objection sustained,
I'm,
and you can ask her, do
okay,
you need your memory refreshed?
okay.
Because I've heard nothing of that.
Yes, do you recall making a statement to the same examination of his mouth making contact with your genitalia?
Yeah.
Okay, and can you tell?
That's not what I asked.
Okay,
But I asked, the
well, I'm
witness,
asking her first. if
let me
she's meant-
speak, okay? The witness indicated that she's never indicated, I don't remember what I said. So is there anything that would refresh your memory? Is the appropriate, under 612, the appropriate way to go? All right, not you cross-examining her on what she said, but you using a report to refresh your memory, all right? So you can ask her, does she remember what she told?
Okay.
Okay.
And she cannot ask her any specific conduct that this witness hasn't already talked about.
Well, that, it would be objectionable as to hearsay, I would think, at that point, but I'll entertain that objection when we get there.
So can you tell me about that? What your memory of that is?
Does she have a memory?
Yes, you have a memory of that, what you told about the same examiner. Wait, can you tell the court about what that memory is?
Your Honor, I'm gonna object to the hearsay. This is what she said to, it's an out of court statement. It's still hearsay, even though it's her own.
I'm not asking about the statement. I'm asking about what is her memory about? Why did she tell the same examiner that? What actually happened with
That
Mr.
was the
Newell to cause?
Does she remember what she told? So you don't want content, you just, do you remember what you told it?
Yes, I don't need to know the statement she
All right.
told. I want her to explain.
She was
what
about to get
happened.
into content.
Yeah, okay.
So,
So I'm
so,
not-
and she's already testified as to what she remembers.
I think it's clear, she's stating that she remembers why she told the same examiner this statement. I'm asking her, why did she tell the same examiner this?
Okay, that wasn't your question,
Okay, then can I rephrase my question?
please.
Okay, so why did you tell the same examiner about that conduct?
Your Honor, I'm not
You said,
sure I understand the question. Are we talking about the conduct that she's talked about where nothing else happened other than the kiss on the neck and the penetration? Are we trying to backdoor hearsay?
I'm not trying to backdoor anything, Your Honor. I'm merely trying to, she's stating that she can recall why she got a medical examination right after the assault that happened. It's been a year and a
Right,
half.
so let's not
I'm not-
testify about that. You got an offer of proof as to that, this is why you're using it.
Yeah.
You're using it, are you using it to refresh your memory? Are you
No.
using it to indicate what she told the other person?
No, I am using it to get into what can she recall from the actual incident that actually happened? And
Based
whether
on
there
her,
was,
based on what?
based on the fact that she went to a medical examination and certain things
So,
were examined.
so
I
she would have
know-
to say she doesn't remember what she said.
Well, I'm not trying to refresh her memory with anything else. She's stating that she remembers now. She remembers now.
I haven't heard her say that.
Okay, well, she stated just before the objection that that is what happened in terms of the mouth to genitalia conduct, and the objection was made as she was answering.
Yeah, I haven't heard that from the witness. I've heard that from you, but I've not heard that from the
Well,
witness.
I can ask the witness,
And-
she just stated that on the record before. that
Response.
objection.
With all due respect to Ms. Kesselman, she is not the witness and she has a proper way to ask questions. And she is leading and she is trying to, as I said before, backdoor for more testimony to come out than this witness has firsthand knowledge of.
Thank you. Ms. Castleman can refresh your memory based on if you don't remember what happened. That's what the court's allowing. So if you don't remember what you said to her, please tell Ms. Castleman that. Do you remember what you said to the same nurse examiner?
I could not tell you word for word, no.
Okay, all right. So do you need your memory refreshed, ma'am?
So would it help you to see what you stated to the same examiner to be able to remember what you stated to her, why you said that to her?
So
So
at
I
this
have
point in
a-
time, you can refresh the witness's memory.
Okay, I'm gonna zoom in solely on this area. There is just this portion.
Your Honor, I believe, I understand that it's electronic and those things cause complications, but she wants to show her like one sentence that is the answer to the question. And it is a hearsay statement still. And if she wants to read the whole report, she should have that opportunity if that will refresh her recollection. I'm just making an objection. I understand we have technical
Right,
issues
right.
here and we have to just do it this way, but
right.
zooming in on the
I-
one question
Yeah.
is,
I've never had a victim review an entire SANE examination, especially not a 50-page MSU SANE examination.
Okay.
The rules to refresh memory are clear, but I'm merely trying to ask about why did she say this statement? I'm not trying to get in the hearsay statement itself.
I understand that. The danger here is that we're creating testimony,
But-
but rather than refreshing memory on testimony.
But it's been a year and a half. I mean, sentence.
It is, and that's why we have refreshing memory as a rule.
Yeah.
So, so I will allow the witness's memory to be refreshed pursuant to 612, understanding the nature of the objection.
I'm just gonna show you the sentence, and then I'm just gonna ask you to review the sentence, and if your memory is refreshed as to this, what happened here, then you can let me know, okay? So that's the sentence right there. Let
And
me
then
know
when she testifies, you should take it away from her.
Yes. So just let me know when you reviewed
I
that.
don't remember saying that.
You don't remember
I
saying
don't
that? Do you recall what parts of your body the same examiner examined during this medical examination?
My vagina, and she took pictures of my chest, my neck. She took a swab of my neck, and she swabbed inside my vagina, and on my inner thigh. And took pictures of my back and pretty much everything.
So in terms of the places that they examined, did you talk to them about what type of areas were touched in terms of what they examined? Okay, and in terms of your vaginal area, what did you tell, or sorry, what was, I guess, what type of, do you recall anything about the type of contact that I was asking you about? Do you
She's
recall?
already
I think
stated
it's
she
im-
doesn't.
Well, I think it's important to clarify whether she doesn't remember that type of conduct happening at all, or if she just doesn't remember the statement.
Well,
But I don't, because I think that's really important for this preliminary examination.
I'm gonna
record,
sustain the
considering-
objection as
considering
asked and
the
answered.
charges. Okay. All right. So in terms of did you have any type of pain in your vaginal area when this happened? Sorry, can you say yes or no?
Yes.
Sorry. Did you have pain during the examination?
Yeah.
Okay. And did Mr. Newell use a condom at all?
No.
Did he ejaculate after this happened? Okay, and what can you recall about that? Like where that was, how that was?
And when he pulled out and it was on my inner thigh, it kind of ran down my butt and yep. Mhm.
Okay. Sorry, what did you say? Last word?
My inner. You have your vagina. When you pull a penis out of the vagina, you got the little, it's like your inner thigh right next to what, the lips of your vagina. So all in that area.
Okay. And did they take swabs? Did they take anything like your underwear at this examination? Okay. And how did your, like right after the assault that happened, where did Mr. Newell go?
In his car. Okay, my son went home.
Did you ever have any conversations with Mr. Newell about what happened that night? And what did he say about it?
He said he didn't know why because I wanted to know why. He said he didn't know why. He admitted once in a conversation that he had raped me.
So you've had multiple conversations with Mr. Newell after this incident?
For roughly a month and a half after.
Okay. And did he apologize to you once, more than once, or something else?
He apologized a bit, but it was more so, I'm sorry, I don't know why I did that.
And since this incident, how has it affected you mentally?
I'm gonna object just to relevancy.
Mental anguish is
I'll allow it. Objections overruled.
How has it affected you mentally?
I don't sleep.
And is that different than your prior problems with sleeping?
Yeah.
How is
'cause
it
I
different?
am on multiple sleeping medications now that still will not help. I've started attending therapy twice a week,
Is that, were you in any type of therapy before this?
once every 2 weeks.
Okay, so that was increased.
Yeah. I've had multiple different med changes. I had a hospital stay a month and a half after.
Did you have any trauma treatment?
Me,
Like treatment for the trauma of the?
that's what
assault?
we've been spent the last year working on.
Okay, so you spent the last year working on that?
Yeah.
And has it changed your day-to-day life in any way, this assault that happened?
Yeah.
How so?
I don't like to be touched at all, and I have 5 children, so that's hard. That's hard.
Okay. Are you worried at all about an attack happening again to you because of this happening?
Objection relevance.
It's in the jury instruction. for
I'll
mental
allow it. Objections overruled.
Are you afraid that another attack could happen to you because of what happened?
I don't sleep.
And has your eating been affected at all by this happening?
My evening's always been kind of rough, so I can't really say to that.
And right after this incident that happened, were you upset or crying at all?
Yeah.
Can you tell me about that?
Called my boss. And sat on the phone for 2 hours and yelled and cried, and
Was that the same day?
it was that night.
Okay.
It was right after he left.
So within like how much time within when he left?
When he pulled out of the driveway and I seen the headlights, and then my son asked me how come Jonathan was on top of me. I told him that he was just giving me a hug, and I put him back to bed, and then I went on my front porch and I cried and I called my boss, and I didn't know what to do.
Okay.
or say.
And how do you feel about being in court testifying in this case?
Don't fucking want to be here.
Okay, and we're just gonna ask you to keep the language.
Sorry.
It's okay.
I
So,
just-
okay, and what was was there any conversations that you had with the police about whether you wanted to move forward with the case or not?
When I had spoken to them and they had told me, I think it was one of the detectives that called me, and I want to say it was like a week after, I'm not sure. I told her that I wasn't gonna proceed with charges
And why did you feel like, well, why did you say that?
because he had just helped his son. I didn't want to be the person to take his son away. I didn't want to hurt him like that. My son clarified.
And since this incident that happened, has he still, or sorry, I would just withdraw that question. In terms of, was there another conversation you had later on, I guess, with the police more recently about pursuing charges?
Your Honor, these conversations with the police are all hearsay.
I think it
Response?
lends to her credibility, Your Honor. I'm not trying to ask her about, I can more so ask her,
But I
I'm
just
trying to
want,
ask whether there was a conversation as to, I need to explain to the court why there was a 1.5 year delay when she first did not want to pursue charges. And there were no charges
but-
until then, and then.
so there's the hearsay is to objection. What is your response to the hearsay objection?
I am not eliciting a hearsay statement for the truth of the matter asserted, or
So-
even
so-
trying to get the statement in.
It's defined as not hearsay.
I do not believe it's hearsay. I'm not trying to elicit the statement. I'm merely asking, was there a conversation? And then I'm gonna ask,
Okay, so you
why
can
does that
indicate,
why did that conversation happen? What were your thoughts behind it?
you can indicate as long as there's no contents.
Yes,
All right, so the objection's overruled. It's defined as not hearsay. We're not getting into content.
so not asking you what you specifically said to them, but what was that conversation? Well, first of all, did you have a conversation more recently with the police about this? And what were your thoughts behind that conversation?
I decided to finally file charges.
And this is hearsay.
This is why I decided to file.
I think
charges
she's
a year
allowed to
later.
say why she decided to file
Yes.
charges,
Okay.
as long as she's not being told that or telling that to someone.
I decided to file charges a year later because I had spent the last year and a half, working through therapy and trying to figure out everything in my own head. And then Jonathan decided that he was gonna move state and he wanted to take our
So
child.
that sounds like you're saying.
So that, I don't know, but in terms of your own reasonings with the therapy, I think that part of the answer is relevant.
As far as her own individual
Yes.
intrinsic ideas, yes, as long as she didn't hear it from somebody or
Yes.
say something to that effect. I don't
Yeah.
know.
And that was your own personal decision, right?
Yeah.
Okay. And when you woke up and Jonathan was on top of you, was he holding your body in any way?
No, he was just on top of me.
Did he have any of his weight on you? Tell me about
But I mean, I feel like anybody in that position would have to have some sort of weight.
Did you have a full range of motion?
No, just my upper half.
Okay. Did you feel that you had the ability to fight back in that moment, considering the circumstances?
No,
And why is that?
I didn't want to risk it. My children. And you never know what could happen in that situation, so.
What were you worried about other than the kids? When you're saying you never know what could happen, like what were you worried about in terms of yourself?
Getting hurt.
Getting hurt by who?
Him.
By Mr. Newell?
Yeah.
What were you afraid could happen in terms of getting hurt?
Anything. In general, I mean, it's not like I wasn't already hurt in the moment, but being held down, you never know if somebody will hit you. You don't know. You never know. Just being hurt in general. You never know.
And how was he holding you down? Like with what part of his body? Okay. And oh, in terms of your relationship with Mr. Newell, was that a concern for you in terms of that was something that could happen, that it could get violent?
I don't feel like he would have ever gotten violent with me. Like, he's a very jealous person. He was always very jealous and very controlling, but he had never gotten actually like completely physical and like laid his hands on me.
Did you feel in that moment that it could have been, that it was a possibility? Was that part of your decision-making process as to why you didn't move?
Yeah.
Okay. All right. Do you see Mr. Newell in the courtroom today? Can you tell me where he's sitting and what he's wearing?
Blue shirt, glasses. Right there.
Okay, may the record reflect the witness identified the defendant?
Any objection to the witness identifying the defendant for purposes of preliminary examination? Ms.
No, Your Honor.
Sotelo, thank you. All right, with that understanding, the witness has identified the defendant for purposes of preliminary examination. Any further questions?
One further question,
Okay.
or two. Around how old are you, Mr. Oh my God, Shirley, right? Sorry.
Right now,
Yes.
I'm 29.
Okay, and around how old is Jonathan?
33.
Okay, but you guys are both over the age of 18?
Yes.
And during the medical examination, did you have any areas of your body that like hurt during the medical examination?
Your Honor, she already asked and answered this.
Or I can rephrase the question.
Rephrase the question. I can't remember if this specifically was asked, but allowed you to rephrase.
Was there any areas of your body that, so were you as part of this medical examination, was there a process at the end of it where they talked to you about the results of the examination and what you should do next medically?
They gave me a bunch of antibiotics. Ibuprofen.
Did they give you any guidance on the results of the exam?
Yeah,
And so when you were being examined, did you see any injuries on your body or feel any injuries?
I don't remember.
Okay, you don't remember? Okay. All right, I don't have any further questions at this time. Thank you.
All right, cross-examination, Ms. Kirsten.
Thank you. May I call you Jasmine?
Yes, ma'am.
Yes, ma'am.
Thank you.
Sorry. You talked about how you and Jonathan had a consensual relationship, on and off consensual relationship. And that was from approximately 2017 to 2022.
Yes.
And when you were off again, would that be because you decided that you didn't want to see him anymore, or he decided, or something else?
I don't feel like not all the time, not every time that we were off again. It was kind of, sometimes it was mutual, sometimes it was me, sometimes it was him. Like it was just kind of a mess of a relationship.
Okay, but that's what you feel like now. That's not what you.
No, that's
Okay, and these sort of on again, off again, I'm sorry, there's cords and all kinds of obstacles.
Yes, there are.
This on again, off again that you're referring to, was there like sort of a standard period of time that you would be off again? Or it was just kind of like you'd end up in the same place and then you'd be on again? Like, how did that work?
So what is your relevance response?
Well, it's relevant because she talked about how it was on again, off again for all these years. And my next question, I'll ask my next question first, and then that one we'll have a foundation.
I find it to be relevant. At issue in this case is some of what are the relationship between the victim and the alleged defendant. So I think it's relevant. Relevance is a low standard in the two-part test. So the objection's overruled.
So were these, how did it turn back into the on again if it was off again?
Well, we worked together for like almost 2 years. And after that, it was kind of just, we would communicate back and forth.
Okay, and isn't it true that the last time that you two were together prior to October 16th was between 8 and 10 days before?
Okay.
And during the 8 to 10 days before, you had consensual sex.
I would just subject this to protected by rape shield. There must be a notice to ask these types of questions. The only relevant information in this case in regards to rape shield is the conduct, I believe, that happened like the night before or right before the assault. You are not allowed to ask, even in a consensual relationship, about other sexual acts that happened 8 to 10 days prior that have no material value.
Okay. My understanding is one of the exceptions to rape shield is a consensual relationship between the victim and the defendant. That's an exception under the federal rule. I'm waiting to see or make arguments on the Michigan rule, but that's my understanding that the consensual relationship, if consensual and deemed consensual, is an exception to rape shield pursuant to the rule.
So, Your Honor, the rape shield statute, and I know the federal statute is very similar. However, there's some very clear case law in Michigan. There's published case law that even in cases with a married couple.
So what case law is that, man?
I'm pulling it up right now, Your Honor. I have these citations. So in terms of, there is evidence Rape shield bars all sexual activity not incident to the alleged rape, even in consensual relationship. That is People versus Saul 127 Mishap 14 from 1983. I also have a specific case. It's called People versus Adar, ADAIR from 1996. This is from 550 Northwest Second
What is it?
505.
And
That's
that-
between,
That
Oh.
says that specifically
yes,
says
husband and wife case.
husband and wife case.
Yes, you
So-
can't talk about the prior sex even a month before or even weeks before. It says that consensual sexual acts between victim and defendant were not admissible whatsoever
At trial.
at trial. And that includes the
This is a
same
preliminary
rules,
examination.
but the same rules, you can't just fish during a preliminary examination and ignore it. Rape shield applies to a preliminary examination as well.
I'm absolutely certain of that,
Yeah.
but this is a different standard and this is a different exception. But I get your argument.
But putting it on the record in a preliminary examination and that transcript is allowed to use at trial, this statute was passed so that this information is not made public, so that victims are not questioned about their sexual relationship with anyone, even the defendant.
What are the exceptions to the Michigan Rule of Evidence Rape Shield?
So the two exceptions to rape shield are evidence of the victim's past conduct with the actor and evidence of specific incidences of sexual
So explain to
activity.
me how this doesn't
Yes.
apply to number two.
So that's what ADAR specifically.
But you're
goes into.
indicating that there's no exception. Number two,
Yes.
you're indicating
No,
that
A
although
is-
there's an
This
exception.
is under A. So this is under A. She would need to file a notice for this in most cases. However, I'm telling you
A
that
trial.
under A is not unlimited. It is very narrow. And
Okay.
it's specific in case law, published case law, that it is extremely narrow. Rape shield is extremely narrow, even within a consensual relationship. If you can't bring in evidence of a sexual act that was very similar between a husband and wife 2 weeks prior to the actual sexual assault at hand, how can you bring up this?
All right, I understand the nature of your objection response.
So, you're on People versus Adair, which is a 1996 case. The defendant was charged with criminal sexual misconduct against his wife. The defendant sought to introduce prior sexual conduct between the two of them, specific acts of conduct. And the court interpreted the past sexual conduct under the rape shield law to mean conduct that occurred before the evidence that was offered at trial, rather than before the alleged criminal offense. And then the court found that the trial court properly excluded that consensual activity is not being probative of defendant's theory that the alleged criminal acts never occurred. So it was a very specific.
But it was a consent argument.
But
Well,
let counsel finish before.
Thank you. I believe it, I have to find all the places, but Your Honor, within the rule, there's a clear distinction between her past sexual conduct with others versus her clear sexual conduct with my client. There's also, under one of the exceptions, an alternative source of semen is an exception.
Right.
And she may not even know this, but there are DNA results that show that there were 2 male contributors. So I just want to ask this one question about this one day. I'm not asking about what's.
That's not what she asked.
Right.
I asked if on October 8th, they had consensual sex. That was the question.
So Ms. Castleman, let's restart. In regards to that one question, do you have an objection?
Yes, that is
Okay.
barred by
So-
rape.
All right, so what I'm gonna have each party to is we're gonna adjourn this preliminary examination. And because this is brand new material, that there's a cross-examination concerning an exception to rape shield, and there's an objection to it. I briefed the matter for the court, and the court will reconsider and review after the briefs are done. So we'll adjourn the preliminary examination for briefs to be filed on the exception to rape shield having to do with consensual contact, which is an exception, but you're relying on case law, and it seems like there's a disagreement as to where the case law is going.
And Your Honor, I will address as well, it seems like there is going to be questioning about whether she had other sexual partners around this time or something like that based on that statement. So I will file first, and then perhaps, since it's my objection,
Right.
so I can file first, and then we can give the defense time to respond?
That's the plan. The plan is to adjourn the prelim for continued testimony. So this, ma'am, this needs that you are still under subpoena. And then I think about 30 days out. So we'll have 2 weeks for the people to file their brief, and then we'll give some time for the defense to file their, and this could affect the cross-examination, of course, of the defense in this case. So we'll set that, so.
Your Honor.
Yes.
I have 3 back-to-back jury trials in April. So if we could have a date, like to come back the 3rd week of May, I would appreciate it.
That's fair. Whatever date will come in, we'll check to make sure that both parties don't have a trial scheduled, because I know Ms. Castleman's also has some trials scheduled. So this is the first date, the first try at this will go at the end. So we're looking at the end of May. Was that the request?
Yes, please.
To be, how does the 16th or 23rd look?
The 16th, I'll still be in trial, Your Honor. The 23rd would be fine for the defense.
Yes, that's also good with me.
There. Afternoon. So let's say on May 23rd at 1:30. But that'll give us some time to block it off.
Can I just ask if the witness has any
Sure.
issues with that? Do you have any issues with that date?
All right.
You said 1:30, Your Honor?
1:30, and that would allow us, that's a PCC day for us, but that allows us to put some time in the afternoon for further argument and then further testimony in regards to it. Brief on the rape shield exception would be due by, so we have some time then. So the brief would be due by, I would think, April 18th.
Oh, that's plenty of time, Your Honor.
For the people. And then brief for the responses would be due to the by May 16th. So that would give you each about a month to allocate time to prepare the briefs with trial schedules also in balance. And then we'll reconvene for May 23rd at 1:30. The witness is still under subpoena, and we're subject. We are on cross-examination. Of course, we'd also have a redirect.
Your Honor, the length of this date getting pushed out does create a little bit of an issue, especially because her therapist, who she goes to 2 times a week, is now sequestered. And I am concerned that she's not going to be able to get her appropriate mental health treatment for over 2 months because of the sequestration order, because she can't talk about what happened today in the courtroom or anything in regards to her testimony with her therapist as of this order.
I think I do think it's fair that she not be she can talk about the event and anything reflective concerning therapy. I don't think the therapy should go into her current testimony at all.
So nothing regarding the court process right now?
Nothing. Once the prelim started and she's taken an oath and under testimony, she shouldn't talk about that with what could be a potential witness for either party, and especially the defense's disclosure. But she can be reflective and talk about anything that happened in prior therapy sessions or anything that happened during the event.
Could I possibly file a motion to have with
Absolutely.
case law so that the court can sooner than May 23rd so that I can address this issue?
You can always file a motion with the court, and I'll always entertain the motion. Just make sure that opposing counsel gets it first so they can file a response, and then it'll come to the court. In regards to any type of counseling and therapy, since I did know I sequestered the therapist as a part of the But that's only in regards to watching her testify. That's not in regards to the therapy that she's involved in already. However, she shouldn't be talking about her testimony.
Can I get a sooner motion date then for that? Like whatever you have soonest?
You can contact our
I'll
office
for it. Thank
and
you.
we'll set it, and we'll make sure that Ms. Satawa also gets a copy of whatever motion and then gets a brief in response, and then we can set it at a date that will suffice. I don't think that would be as long a hearing. I wouldn't take as much time, but I certainly would entertain a motion on that.
Thank you, Your Honor.
And Your Honor, as you know, my client resides in Arizona. Would he be able to participate by Zoom?
For a preliminary examination.
Yeah, I don't think he
we
can.
should
I
What
don't-
about the motion, the motions?
Oh,
The motions he can, not the actual prelim.
but so I would agree in terms of my motion for the sequestration situation.
Right.
But I would assume that we would have more testimony on that.
Yes, for the prelim, for the date prelim on May 23rd, he's got to be here.
Okay.
Because that's just a continuation of this prelim.
And
For
I
the
wasn't clear
motion,
that's what.
yeah,
was
for the
happening.
motion,
Okay. Yeah.
I think if he chooses to attend, he can attend by Zoom. His appearance can be waived for the motion for that motion part of it pursuant to the modification of bond. But if he chooses to attend by Zoom, that's allowable for the motion.
Okay, thank you.
I do have a bond motion I would like to make really quickly, Your Honor.
All right, yeah, you may proceed.
I believe we
Isn't
have
it
a
just a
stipulated,
stipulation?
yes, we have it, I'm not, don't worry.
Like, what is she
So,
doing?
no, so I believe we have a stipulation, they have the defendant and the victim have a shared child together, there is currently a no contact order. There is a custody order between the two that has been agreed upon already well before this. So to facilitate that, I think third-party contact regarding the minor child only should be allowed. Only third-party contact, I don't want direct contact between defendant and victim. Just to make sure that that custody arrangement can keep going through the pendency of this case.
So my understanding is there's a stipulation as to the bond condition allowing third-party contact in relation to the children only. Is that correct?
The child only,
Which child is
one
that?
child, it's Kyler, right? Is that correct, Jasmine?
KYELER.
KY.
ELER.
Mr. Tao, is that your understanding?
Yes, I just want to be very clear about what third-party contact
Right.
means. So we are agreeing that a third party can contact
Kyler.
can contact Jasmine
Yes.
and arrange date and time for video visits right now, and then in the summer it changes, but we'll just talk about the video visits right now, between my client and Kyler, and then they will have those video visits, just the two of them.
And that's pursuant to an order that's already in place
Correct.
with the custody order.
Yes.
Yes.
So- And then,
What Mrs. Tao is she's afraid that she doesn't want a bond violation out of this. And so it's that's why we're being real clear on detailed third-party contact for the following the order that's already been agreed to upon. There's a stipulation of the contact between the defendant and the child, but testimony should not be discussed.
no, and then also, I believe that we would need to also allow for third-party pickup and drop off of Kyler, correct? Because he has in-person visitation too that they've agreed upon. And I just want to make,
Pick him up from the airport, so somebody would have to drop Kyler off at the airport and for Jonathan to meet him at the airport, like, pick him.
but to arrange that, that's been done in the past, they've had these visits in the past.
Right.
So just arrange that through a third-party person.
And that's your understanding, Ms. Satawa, is that the arrangement would require some contact, and that third-party contact is part of the modification of bond.
Okay, and is the contact by phone, by email, how are text, how are we having this contact?
What do you usually do to arrange? Are you okay with third party calling you and texting you?
Yeah.
Okay, is that the best?
What do
way
you
to be
prefer?
fair?
I can text or call, just depending on them, really.
So any cell phone,
I'm a-
text or phone call
Yeah, or
contact,
video call with the, yeah.
let's
It's
not,
on her cell phone, the video call
All
would
right.
take place, correct?
but
Yeah,
that
like
wouldn't,
that.
that'd be between the third party and her.
Yeah,
Yes. So third party could call her, defendant could get it, defendant could get on once she leaves and puts Kyler in front of the phone. I just want to make sure that the custody order can be
Yeah,
followed.
The custody order, and there seems to be a stipulation that the custody order is controlling any third-party contact. And this is a little bit more flexible, but it by cell, video, or text can be made in order to make arrangements. I say I'll tell you right now. So we're adding that little bit of flexibility. I'm somewhat uncomfortable with the pretrial bond release. I'll modify it at the request of parties, but I want it to follow that order, and I'm going to be reluctant to violate a bond based on third-party contact when the defendant's just trying to arrange some type of meeting with his child.
Yeah, I don't think it's gonna be an issue.
There's one more thing.
Yeah.
My client was supposed to have parenting time starting tomorrow.
Yeah.
So, I guess, hold on.
And she just nodded, yes. She said, yeah.
yeah.
So you don't have
He was supposed to go originally to Arizona starting tomorrow for spring break.
so you're
But-
requesting.
So we're requesting that happen.
All right, and the victims indicated on the victim in the alleged preliminary examination has indicated that can start tomorrow. Is that correct, Ms. Castleman?
So I think that some arrangements still need to be made. So
Right.
that was the original plan before the criminal case came to
Right,
happen, and there was a no contact order, which I think stalled some communications. So I think that there would probably need to be some communication with you based on my conversation with you about arranging when he's gonna travel there, correct? Are you ready for him? Like, I'm sorry today. It's weird to do this in a preliminary.
Right, it's
examination
all right, it's
situation,
all right.
But, are you comfortable with him going on that trip still? Or, I mean, it would be like a surprise to Kyler, correct? Or do you want me to, can I speak to her really quickly?
you may,
Okay.
yeah,
Well, maybe we can, do you want to both talk for a
right,
minute?
because this
That's
seems to be a
fine.
little bit
This
above
has
beyond,
nothing to do with the case.
right, beyond the purview of the preliminary examination. But if you're
Because it's a
requesting me
young
to
child.
modify bond,
Yeah.
It's only 4.
all
Yeah,
right.
and he hasn't seen him in a while.
So
let's go-
talk to the assistant prosecutor.
Yes.
We'll find
Let's
a
go
way.
chat real quick. So
Okay.
I'm sorry that you're having to deal with this, but we want to deal with this. We're gonna go out.
All right.
Yes, thank you.
Ms. Wilson, did you want to lunch today? Did you want to, I'm leaving it kind of up to you.
So the bulk of my officers are on duty right now, so I would prefer to just go straight through so I can get them out as soon as possible.
All right, all right. I don't have a preference.
I'm told it's busy, so they need some assistance out
We've
there.
got some,
If we want to put Mr., I don't know, if we want to put Mr. Gatlin on the record real quick, it's just gonna be an adjournment.
I think we can put a Sherman on the record. Is that Mr. Austin? Who's case?
Yes, Your Honor.
Is that Mr. Carr?
Mr. Austin, or Mr. Gatlin.
All right.
Dominic Gatlin.
Let's go ahead and put that adjournment on the record.
Okay.
All right, so we're taking a brief break from docket 24-00189, and we'll call to the record docket 24-00359. That is people of the state of Michigan versus Dominique Gadlin. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson, people.
Mr. Austin.
Good morning, Your Honor. Jared Austin appearing today on behalf of Mr. Gadlin. He's standing present to my right.
And sir, you are Dominique Gadlin, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Gadlin is still in the process of retaining private counsel, so we would be requesting a joint adjournment of the preliminary exam.
And that's a fair statement, Mr. Austin.
That is my understanding after speaking with Mr. Gadlin, Your Honor. He has an attorney in mind. It sounds like he's just needs a little bit more time to come up with the funds to retain that particular attorney.
Okay, so your plan, Mr. Gadlin, is to get a private counsel to retain private counsel, and therefore you're requesting an adjournment for today's date in order to do that. Is that correct?
Yes, sir.
What is the name of the attorney that you're thinking of?
Fred Black.
Right, I'll indicate that the defendant waived the 21-day rule on May 1st, 2024, without objection from Ms. Wilson to the adjournment to get retained counsel. We'll reset this prelim, all right?
Thank you, Your Honor.
All right, and reset this for? April 12th at 8:30. Anything else for the record in 24-00359, Ms. Wilson?
Not from the people.
Mr. Austin?
No, Your Honor. Thank you.
All right, Mr. Gadlin, we'll see on that April 12th at 8:30 date. You have until that date to get retained counsel, okay?
No.
We have Carr.
It would be a plea, Your Honor.
Okay. Yes.
I believe
Brown.
we're prepared to go with him next when the court's ready.
All right.
And that's
Yes.
gonna, I believe, at least be the start of an exam.
All right. So let's hold on to that.
Yeah.
And then Brown would be one of, so Brown is Miss Wanchi, and that's gonna be a prelim.
That is the continuance of a prelim, correct?
Ma'am, on the Jessica Jalecia 81, could you please identify yourself and what case you're here on?
Hi, my name is Jessica Navarre Alicia. I'm sorry, I don't know the case number, Your Honor.
Okay, you don't know do you know the name of the defendant that you're here on?
No, it's just myself for an OWI third offense.
I have.
Ma'am, that's what I'm afraid of. I'm afraid you're in the wrong courtroom. So let's, how do you spell your last name?
Alicea. Alicea.
Alicea.
Correct.
That's her first name or her
Last name.
That's my last name.
Jessica.
Correct, Your Honor.
That's, looks like Judge Simmons.
Judge Simmons.
Was Sarah Donnelly from our office.
So ma'am, you should be in Judge Simmons' Zoom courtroom, and Sarah Donnelly is your attorney.
Okay, I'm sorry. I handled a matter at 54B earlier, so that was what my
Right.
attorney. Okay, so
Right, so
what do I need to do now?
you need to go by Zoom to Judge Simmons' courtroom, and I can give you that courtroom ID number, I think.
Okay, I can look it up, Your Honor.
All right,
Is there a
all
way
right.
to know? I won't be in contempt, will I? Because I've been waiting for your courtroom to be
yeah.
available.
You can tell them that I can vouch that you've been here for about an hour. But
Yeah, no, I've
so
been
if
here
they
since
want
9 a.m.
all right,
Yes, it's
but you're in Judge Simmons' courtroom, so I bet you the case has already been called.
Oh no,
Let-
yeah, no, it's 9 a.m. It or B at 10 a.m. and
All right, stand by, ma'am, and I'm going to check on you.
Okay, thank you.
I don't know why. I piece of seats reset.
All right, so ma'am, it appears you should get in hold with your attorney, Sarah Donnelly from the Public Defender's Office. It appears that case was reset, and you can tell them what happened. So contact your attorney, Sarah Donnelly at the Public Defender's Office, okay?
Will do. Thank you, Your Honor. Appreciate you.
You're welcome.
Okay, bye-bye.
All right, so we're on the record in docket 23-01833. That's people of the state of Michigan versus Joshua Carr. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Carr. He is present to my right at council table.
Thank you. And sir, you are Joshua Carr, is that correct?
I am, Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to an added count of use of methamphetamine. And I have provided the court with the PAC code previously. I don't know if you want me to reapply it. Okay.
No. So let's be an added count two of use of methamphetamine. Is that a fair statement, Mr. Austin?
It is, Your Honor, and that's what I've conveyed to Mr. Carr.
All right. And I know that there's going to be some additional argument concerning sentencing in this matter. Mr. Carr, is that your understanding? You'll be pleading guilty to a count two of use of methamphetamine that is punishable by 1 year and or $2,000. That's your understanding. Is that correct?
It is, Your Honor.
Okay. And then with the successful sentence, a plea with a successful sentencing on that, count two is to be dismissed for the plea negotiations.
That is correct.
All right.
And the habitual offender.
Mr. Austin, may I inquire of your client of his advice of rights plea?
You may, Your Honor, and I have executed an advice of rights.
All right, thank you.
With that.
All right, Mr. Carr, it appears that you have signed an advice of rights that I'm in possession of 23-1833 FY, indicating the 12 trial rights you have, and you've been able to sign this pursuant to your advice of rights plea information. Is that correct?
It is, Your Honor.
I'll just go over the three main ones with you in regards to this, and I'll attach this in the file. You understand you have the right to trial by jury. You have the right to have counsel present to question any witnesses brought against you. Counsel is Brian Austin today, and he would be present to cross-examine any witnesses or contest any charges brought against you. You also have the right to remain silent, not to have that silence used against you, not to be in testimony against yourself. Do you understand those three rights?
I do, Your Honor.
If you please accept it, you'll give the claim the plea was a result of any promises other than the plea agreement, which is stated on the record, or threats that it was not your choice to plead guilty. You're giving up the right to appeal issues that may otherwise be available at a trial. You won't be having a trial. You'll be pleading guilty instead. Is it your intent today to waive your trial rights and plead guilty on the matter?
It is, Your Honor.
All right. If you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
All right. I'm going to bring your attention back to February 20th of 2023 at in the city of Lansing, Ingham County. Were you in the city of Lansing, Ingham County on February 20th, 2023?
I was, Your Honor.
And on that date and time, did you use methamphetamine?
I did, Your Honor.
And you knew it was methamphetamine when you used it?
I was aware.
And you did not have a prescription or any type of doctor's note or prescription to use it?
You are correct in saying that.
All right. Anything towards a factual basis, Ms. Wilson?
Not from the people.
Mr. Austin?
I'm satisfied, Your Honor. Thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. I know there's going to be a request for immediate sentencing in the matter. So Ms. Wilson, would you like to be heard on sentencing?
The only thing I would say, Your Honor, is, Mr. Carr does seem to have a history with this type of behavior. It's my understanding that he's currently being held on what appeared to be a $20,000 bond out of Eaton County. So I would just request that the court take those factors into consideration.
All right, Mr. Austin.
Yes, thank you, Your Honor. Mr. Carr does have a matter pending in Eaton County. It's still at the district court stage where he has some felony charges pending there involving firearms and CCW and resisting the police. So it may be quite a while before that matter is resolved. And obviously his bond is a matter there that he's not going to be able to post. So even if the court wished to impose a sentence of probation on him in this matter, it might be a considerable amount of time before he would even be available for that. So given that, Your Honor, and the reduction in this and those pending charges looming, I would just ask the court to sentence him to some nominal jail time and give him credit for the time that he has presently served on this case.
All right. I'm not adverse to immediate sentencing in some matters. There seems to be a prior offense notice here and an ongoing Eaton County case. So I need to know more about it. I just need to know more about the file concerning this matter. So I'll refer to probation for a pre-sentence report. Is there a bond on this file, Mr.? If there's, so he should be collecting any time and there shouldn't be any dead time on this file.
Yeah, it looks like there's a 3,010%.
All right, so he's not made bond on this file.
I don't believe
All right.
so.
That is correct, Your
All
Honor.
right,
So he's
so-
been accruing.
So he's been
credit.
accruing jail credit, so to speak. All right, I'll set the sentencing date. And in the meantime, probation will be down to talk to you. And then and they'll prepare a report for me and we'll see what options are available. And we may know what's going on in Eaton County by the time we're all set.
And if I may, Your Honor, I
Yes.
know that I'm not going to be posting bond in either Eaton or Ionia. I also have a $60,000 cash, no surety bond in Ionia.
Ionia?
Yeah, but
Okay,
that's
so you'll be collecting on all this, collecting
I
time
do
on
have a
all
writ
this.
of habeas corpus in for Ionia, but I don't believe they are aware of that being filed as of yet.
Okay,
So
all right, so we'll set a sentencing date for
May 23rd at 9.
May 23rd at 9 a.m. So probation will be down to see you. You'll be collecting time as we go. You're in on other stuff too. I mean, on the Eaton County stuff too, and on the Ionia County stuff. All right, and then we'll see what options are available. It may be that we don't want to duplicate any probation that you may be on, but let's see what they say. Okay.
I do also know that Eaton County is looking at anywhere from 48 to 108 months.
All right, that might make a difference. All
Yes.
right, all right, all right. So anything else for the record? 23-01-833, Ms. Wilson.
Happening, people.
Mr. Austin.
Nothing additional, Your Honor.
All
Thank
right,
you.
thank you, Mr. Carr. You're all set.
All right, talk to you soon.
Yes, sir. We'll be in touch.
What is it? Brown next?
Yes, Lamar Brown.
No, it's one of his previous cases. I think it's a firehouse case where it's like unpaid.
I see why you were making the motion for immediate sentencing, Mr. Austin. Well, we may go that route anyway when we find out that he's in the Department of Corrections, but yeah.
Remarkable.
Notes on Brown.
Oh, I thought I did something on fire.
I didn't see it. I didn't think on his charges out there. I just thought I saw the three. Unless they added it. Sure.
There's all sorts of stuff over here today.
Possession of a firearm, CCW and R.
Yeah.
It's kind of a song.
All right. Ms. Holden, I do have exhibits for Brown.
We didn't mark them last time?
No, they're new.
Okay, give me 1 second. Let me finish this email.
No problem.
Please. So they can go see Mr. Carr. Okay, Ms. Wilson, what you got?
I have a flash drive with 1A and 1B.
say the 1A and 1B?
Correct.
Okay. It looked funny when I typed it. Oh, boy. Did I get?
I have one more. This is gonna be 2.
You email this to me when we're off the record.
Yes.
It helps us when we type the transcript.
Gotcha.
Tremendously. If we can read it, if we have to.
Yeah. Thank you.
You're welcome.
I didn't send it.
Uh-huh.
No, I didn't. I send that I'm leaving to the messenger too.
What should you send it to?
Did I? I must, it's in my sent box. So I
Oh,
didn't
you
send
must
it.
have sent it.
At 8:33. So it's me, Buchanan,
Oh, SMS report.
and
Where did it go?
Michelle Lynn Thompson.
Ah.
All right, we're ready to go on Mr. Brown's case. So we're on the record in docket 24-00370. That's people, the state of Michigan versus Lamar Brown. Will the parties please introduce themselves for the record? Miss Wilson,
Joe Wilson for the people.
Miss Wanchi.
Brenda Luciana from Mr. Brown.
And sir, you are Lamar Brown, is that correct?
Yes, sir.
Thank you. This is the time set for a continuation of preliminary examination Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I am prepared to continue the exam today. I do have two witnesses here today. It's my understanding, however, in looking at some of the evidence that was supplied previously, that there was some kind of technological issue with some of the jail calls being sent over to the defense. I know I couldn't play them on my end, so I think there may need to be another continuance in order to get those over properly and get them addressed.
So, Ms. Wanji, are there some discovery issues concerning additional evidence that you need to review?
That's why, I was not able to do this.
Yeah, I just discovered it the other
Right,
day.
so for
Yeah.
whatever reason,
Yep.
technology fails us again, and we're not able to hold those. All right, so with that understanding, Ms. Wanji, what I'll do is we'll let the people go forward. If you want, we can have the people recall witnesses so you can cross-examination. So you won't complete your cross-examination today until you see and review all the evidence. I think that's fair.
That's fair, Your Honor, yes.
All right. All right, so with that understanding, Ms. Wilson, you may call your next witness.
Thank you, Your Honor. Before I call that witness, I will say that the complaining witness is here in the courtroom today, and she did testify previously. She is still under sequestration, so I do believe she needs to exit the courtroom.
That's true, and we have a sequestration order. No witness can watch another witness testify. So is the previous witness is Nichelle Lynn Thompson, is that correct?
I believe it's Thomas.
Thomas?
Oh, is it Thompson? I keep getting it mixed up. I apologize.
So, Ms. Thompson, we're gonna have you exit the courtroom with, I'm sorry? Yes, yes. There's this question, so you can't watch another witness testify. There's a sequestration order. You're a witness, you've already testified, and you can't watch another witness testify. All right?
Let me know that I've been seeing her for like 5 hours.
All right, well, that's, you need to ask the assistant
They told me
prosecutor.
to come to every day. That's why
Okay.
I'm here to.
All right, you're now not here. And Ms. Wilson, you may call your next
Your
witness.
Honor, the people call Officer Tyler Stover.
Okay. All right, is it Tyler Stover, Officer Stover? You can come up. Please stand right in front of me and state your first name and last name for the record.
Tyler Stover, TYLERSTOVER.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I swear.
All right, thank you. Go and have a seat. The microphone is for recording purposes. I'd have you project to the back of the room. And Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Stover, where do you work?
I work for the Lansing Police Department.
And what are your general duties?
I work patrol typically to respond to calls for service. They come in through Ingham County Central Dispatch.
And were you working as a police officer on February 9th, 2024?
I was.
How were you dressed on that date?
I was wearing the police uniform I'm wearing today.
And Your Honor, I'd just like the record to reflect that Officer Stover is in uniform today, and there are several denotations of police on the uniform.
Thank you. And without objection, the witness is in uniform today. And the record should reflect that.
Thank you, Your Honor. Now, Officer Stover, on February 9th of 2024, were you dispatched to 2434 Rio Road?
That is correct.
And is that in Lansing,
That is correct.
Ingham,
Correct.
Michigan?
Yes.
And what were you dispatched for on that date?
I believe it was a domestic assault.
And what happened when you first arrived at the location?
When I first arrived, I spoke with the victim,
And do you know who that person was?
Nichelle Thompson.
Okay. Did you observe anything notable about Ms. Thompson?
She was crying and upset when I first spoke with her.
Okay. Did you obtain any, let me back up real quick. What was her relation to the call that you were responding to?
She was the victim of the assault and she was the caller, I believe.
Okay, and did you obtain any information about the relationship between Ms. Thompson and her assailant?
Yes, she said that they shared a child together, a 9-month-old child. Aiden, I
Okay.
believe, is the first name of the child.
And on that date, were you wearing your body worn camera?
I was.
And is that something that's department issued?
It is.
Okay, was it operable that date?
It was.
At some point in your response to the call, did you turn it on?
I did.
Okay. Your Honor, if I might approach the witness.
You may.
Thank you. Officer Stover, do you recognize that?
Yes.
And what is it?
That's the USB containing the body cam.
Okay.
Me earlier.
And did you have an opportunity to review that prior to this date?
I did.
Okay, and are the contents of it a fair and accurate representation of what you observed that date?
Yes.
Okay. Sorry, Your Honor, just technology real quick.
No worries.
Okay. Oh, and for the record, the USB was People's Proposed Exhibit 1. I apologize, I don't think I put that on the record.
So is there a motion to admit People's Exhibit 1A?
There is, and it contains 1A and 1B.
All right. And they're both videos from body cam.
Correct.
Any objection to the admission of People's 1A or 1B?
No, Your Honor.
Without objection, 1A or 1B are admitted. You may publish.
Thank you, Your Honor. All right, and just for the record, I'm gonna jump ahead a bit because it takes a second.
Oh, no, okay.
Okay, and for the record, I'm starting at minute 0:28.
Oh my gosh, he wanted y'all to get him anyway.
Are you okay?
No, I'm not okay.
Want medics to come up?
Yes, please.
Medics are going to come up. Are these his shoes right here?
Yeah, can you come look at my hose?
Is he?
He was banging my head on the wall.
Okay.
He was banging my head right here, sir.
Is he?
And sorry, I'm just gonna pause and at this moment right here, Officer Stover, oops. Do you see in the right-hand corner there a hole in the wall?
Yes.
Okay, and about how tall would you say Miss Thompson is?
I don't recall exactly.
Okay.
If I were, I would say around 5'9".
Okay, and in your estimation, is that hole in the wall approximately standing height with her head?
Yes.
Yes, okay. And I'm just gonna go ahead and continue playing.
Happens here. Y'all didn't supposed to be around me.
Okay. Can I start with your name? How do I spell your name?
I'm sorry, let me come.
You're okay. You're okay. Take a second. If you have an ID, if you want to work on grabbing that.
I don't even know. All right.
Did he have a gun on him when he was here?
No, he already stole my license gun.
Yeah. Oh, I saw that. That's why
He
I
stole
asked.
my gun, he stole my car, he stole everything out my house, everything.
Okay.
I gotta come, I'm sorry.
Okay. You're okay. You're okay.
My head just hurt from him hitting my head on the wall.
What time did all this start?
Just not even probably 15 minutes before y'all just came.
Okay. Medics are coming out, so I'm gonna take some photos of you, okay, and some photos of the house. Is that okay?
Yeah. And I just moved here.
You said that's where you sitting?
Yeah, banging my head on the wall.
Oh my gosh. Okay.
I got a camera too, right here.
Do you?
Yes.
Is it recording?
Yes, it is.
How can you pull that footage up for me?
On my phone.
Okay. Can you tell me what happened? Like, how did this go down?
Basically, like I told, because I'm going through some CPS stuff, basically, or whatever. He had, before I got what he had.
All right, and that's for 1A end. And Officer Stover, there's a bit of a break between your body cam footage. Do you recall why that was?
I believe I was resting my arm on my body cam and accidentally turned it off.
Gotcha, okay. And then permission to publish 1B, Your Honor.
May.
I'm like, why would you say that? Anything is possible to happen. Somebody could lose their temper, or anything could trigger somebody to do anything. You know what I'm saying? And he's like, he don't face reality, so he get mad because I'm saying like anything is possible to happen. So that's how the argument started from nothing, basically.
Yeah,
so he's like, because I'm just getting angry, and when I get angry, my head is like, you know what I'm saying? Like, so he's like, why are you doing that to me? Like, I feel like he just wanted to pick a fight.
Sure.
Like, he wanted to come and just try to pick a fight. So basically, I'm like, you can get out of my house. You can get out of my house. I'm not going nowhere. So I tried to call my friend. I told him to come. He's like, oh yeah, I'm staying now. I'm about to whoop his. I'm about to beat him up. I'm about to beat him up. Like, I opened the door just like this. Like, please just get out. You don't supposed to be around me anyway. Just go. Then that's when he came. He's like, what'd he say? Cause I said, just get out of my house, just go. And I guess he got super mad because I did like this, like, just go. He grabbed me, sir, like, bang. Then before he grabbed me, he grabbed his table, he was like, blows my table and everything.
So he grabbed you by the neck and did that?
Yeah, it's right here, like, bang, bang, bang. And it's like, and then he said, call the police. Like, he wanted to go to jail. So he's like, call the police. And that's when I called you guys. First I called the CPS guy, and he told me I had to call you guys. Then when he left, he made it seem like he was about to run or something through the field. So I told the officer, and she said, well, just don't try to follow him or nothing. So I just came back to my house or whatever. Then he came back, and then that's when y'all just came.
Okay. When he grabbed your neck, were you able to breathe at all?
No, I was not. I was just scared because I'm like,
18.
why are you choking me?
I'm gonna go ahead and pause at minute 1:49. Now, Officer Stover, you said that that's a fair and accurate representation of what you saw on that date?
That's correct.
Okay, nothing further, Your Honor.
Cross-examination, Ms. Wanji.
Thank you. So you did not observe the alleged assault, correct?
No, ma'am.
You came there and whatever your camera or whatever your video, the video is showing what was told to you by Miss Thompson. Is that correct?
That's correct.
And that what you observed also that day. Is that correct?
That's correct.
Now, Miss Thompson also told you from what she said, she was the one who touched him first. Is that you understand it? When she asked him to, she testified that she asked him to get out of his home. Is that correct?
Yes.
Your Honor, I'm going to object. The question was what Ms. Thompson testified to. Mr. Stover has no knowledge of what Ms. Thompson testified to.
You can only answer what he knows.
Correct.
So with the understanding, the objection sustained, you can ask him if he knows or not. He only knows what he heard. He can't testify.
I misspoke, Your Honor.
Okay, thank you.
From what your video recorded and what she told you is that she asked him to leave the home, correct?
Yes.
And when she was making this, she said she touched him and said, get out of my home. Well, with the intent of asking him to leave her home, correct?
Yes, that's correct.
And is it your understanding that she was the first one to touch him?
Yes, she made a pushing motion towards me when she.
I have no further questions, Your Honor.
All right, thank you. Any redirect, Ms. Wilson?
None for the people, Your Honor.
All right. May this witness be excused from the people?
You may, Your Honor.
From the defense?
Yes, Your Honor.
All right, you're excused. Thank you for your appearance. And Ms. Wilson, you may call your next witness.
Thank you, Your Honor. The people would call Detective Stephanie Kennedy.
All right, Detective Kennedy, I'll have you come up here. And if you can face me and state your first name and last name for the record and spell them both for the court recorder.
Stephanie Kennedy, STEPHANIE KENNEDY.
Please raise your right hand. Do you solemnly swear or affirm tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, have a seat. The microphone is for recording purposes, and please project to the back as best you can. Ms. Wilson, when you're ready.
Thank you, Your Honor. Detective Kennedy, where do you currently work?
Lansing Police Department.
And what are your general job responsibilities?
I'm currently assigned to the Detective Bureau and I work in domestic.
Okay, and at some point, were you assigned to a case involving the Lamar Brown?
Yes.
And what was your assignment?
To review jail.
Okay, and so just a little bit of background here. So in the jail call system, can you explain a little bit how that works?
I guess more specifically, what do you mean?
I guess like how you're able to access them.
So we have the ability to access them and we can run a variety of different ways. It can be by date, it can be by inmate, it can be by a specific phone number, it can be by a name of person they're contacting.
Okay, and did you have occasion to look at Lamar Brown's prison messages or jail messages?
Yes.
And did he have any contact with anyone in those messages?
Yes.
Do you know who he had contact with?
It actually said Lamar Brown.
Okay, and to the best of your knowledge, was that in fact Lamar Brown?
No.
Okay, how do you know that?
Based on the conversation and the previous jail calls I listened to.
Okay. Your Honor, may I approach?
You may.
I'm handing Detective Kennedy what's been marked as People's Proposed Exhibit 2. Detective Kennedy, are those some of the messages that you observed or you saw?
Yes, they appear to be.
Okay, and I'd like to direct your attention to, I believe it's the second page there. Yes. What date is that middle message?
February 14th, 2024.
Okay, and can you, I see there's a portion highlighted there. Can you read that portion?
I hope all of this is behind us soon and the letter to the judge helps.
Okay, and based on the context of that message, who did you understand that message to be relayed to?
From the victim in the case.
Okay, and in the course of your investigation, did you look at any bond conditions that the defendant might have?
No, but I'm pretty clear of most bond say that speak to the
Okay.
victim.
All right. Your Honor, at this point, this is the witness that I would need to get those jail calls in that were funky in the evidence.com. So I will need to recall her,
Right.
but at this time I am done.
All right. All right. So Detective Kennedy, you're still on the stand. Miss, did you want to wait for your cross-examination? All right. So Detective Kennedy is still on the stand, subject to direct and cross based on the outstanding evidence that has not been able to been reviewed since we can open it for whatever reason.
I figured that out.
Okay, so we will allow the defense to review the documentation and we will reset. So this is a continuation of the prelim, and we've got Officer Stover now has testified, and then we've had partly Officer Detective Kennedy has testified, and will continue to testify, and we will reset the prelim and adjourn to
Is 2 weeks enough time?
2 weeks.
That should be enough.
April 5th. 30, that works for everybody?
So April 5th at 9:30. That should give defense counsel enough time to review the new discovery and the new tapes. Ms. Wanji, does that date work with your schedule?
I may be in the middle of the car that day.
Okay, so you might be in the middle of a trial that date.
We can push it out another week if that's probably the best course, just in case.
So how's April 12th look?
We already have much resets. Can we do that on TV again?
If we're
How about April 11th at 9?
April 11th? Right, that's the same trial, that's the same week. Are you in trial on April 11th?
I start on April 3rd.
April 3rd.
What kind of trial is it?
It's domestic.
I
don't think that they have a lot of.
let's stick with the 12th date, then let's do April 11th. That's a good, that'll be a full week, and then if it becomes a problem, you just let me know, all right? And we'll reschedule. But April 11th at 9:30, the defendant is incarcerated, so we want to make sure that we do this timely. So we'll set it for April 11th at 9:30, and then I'll leave it to council to apprise me if that date doesn't work out, okay? Detective Kennedy's still under subpoena. Anything else for the record in 24-00370, Ms. Wilson?
Yes, Your Honor, I would just ask that the court hold Mr. Brown in contempt. As Detective Kennedy testified here today, he has been contacting the victim while he's been under the no contact order. Additionally, I would renew my request that his phone and messaging privileges be revoked. It's my understanding and looking that he is still able to at least message.
Yeah, I have that based on testimony.
If I may.
You may.
I haven't finished up with, I haven't cross-examined the witness. The discovery is not appropriate at this time. So I believe that it's unfair to have my client put in contempt for something that we just started.
I have grant motion denying contact and privileges.
Yeah, it appears that he's still able to message, so I don't know if the jail needs another.
That would be in violation.
Yeah, but I'm not.
Okay.
I don't.
All right, so once again, I'm granting the motion. This motion was initially set on March 1st, 2024, to denying any privileges, only as to speak to his attorney, not to speak to anyone else. I don't know why that order wasn't followed the first time, but so I'm granting the motion to deny all privileges at this time, and then we can reconvene on April 11th.
So I'm not even allowed to talk to my father, my mother. Or...
That's correct, sir. Only allowed to talk to your attorney. That's correct. Anything else for the record? 24-00370, Ms. Wilson.
Not from the people.
Ms. Wanchi. All right, thank you.
Rio? Ms.
Matthew
Robinson, are you ready?
Room?
Yeah, okay.
And you're all set, Ms. Kennedy. Thank you.
Yeah, thank you. So, yes. Yeah, Adam White. Yeah, he's the one that figured it out. So, yeah, I can play him. Yeah, thank you. Okay, thank you.
And then I think you've still got your exhibit published.
I do, yes.
Rome.
Ream.
Ream.
Yep, like a ream of paper.
Ream.
You have one. I'm sorry. Should be my last one for the day. Fine. Not even. Where's it? Right here. Thank you. And this should just be one. Yeah.
And then Mr. Austin, you have Mr. Hibbett, correct?
Sir.
Oh.
And then we still have Hanson. Hey, Tim. Hey, Tim. Something to eat.
If I sit still too long, like nothing works anymore. Ever.
Yeah. Isn't it? Oh. You can't have.
I have a PCC at 1:30, and then I have to be in circuit court at 1:30, and then I have another thing in circuit court too.
I have to be in certain point.
Oh my God, what do you have?
First pre-trial.
Do you know, like, do you have a plan for what's happening?
It's that.
Okay. Do you want me to handle it while I'm there?
Yeah, if you could.
Okay, what's his name?
Hawks.
Okay, and you've already talked to him and everything, so he knows what's up.
Yeah, cool.
Yeah, I can handle it.
He's a late back guy.
Sounds good. I have to run this dumbass PE. She's from the natural. Yeah, I know. She's so.
Like my guy, he's really confident and it's still.
Yeah.
Machines like he always does.
I was just like, dude, like, and the offer was just to, like, you know, move the felonies and then, like, I'm not sure where it is. So it's just, like, it's like, and it's like, but it's like 2 months of that for me. I'm just, I'm already, I just sent it to myself. Like, you know, probably, I'm gonna be on probation. But no.
Yeah. Not great, no. I should probably check, make sure my officers didn't I thought he was in custody. When was he released? Yeah, the last I looked, he was in custody. Still showing us him in, oh, she left. Still showing us him in custody.
I had a colleague come yesterday with him, didn't show. What day is your custody stuff?
I was just in a jail.
Yesterday we check on him, he was not there.
Nah.
And I
Not the first time they lost people in there.
And I had my colleague come, he didn't show.
Okay, I guess I'll have to, or we'll see if Wendy, yeah, if you can go downstairs.
What's his name?
Hanson, Joshua,
Hanson?
Hasen. Oh, I know, Hansen. Hansen.
Okay. Joshua, did you say?
Yeah,
Let's see if he shows up on Ingham County, I'm assuming.
yeah. I hate the freaking captcha thing.
What kind of robots are trying to see who's in jail?
Maria was even helping me. She like, and that one, then I check also.
I don't see any cars.
You don't see.
I don't see any. It's a trick question. Do you see a car? I guess there's a little one there.
No.
I'm gonna go.
Finally. Yeah, he's listed as being there.
Yeah.
That's him. Yeah, he's there. Looks like he's got a hold for me, county too.
And I thought I was done.
Hansen, Joshua Hansen.
Oh, jealous. He's still listed at county.
Okay. Maybe he just chose not to talk to Ms. Swangy yesterday.
Joshua Patrick Hansen.
Yep.
He's still listed at county as of
Alright.
this morning at.
Or sometimes the deputies just don't.
So they just don't, yeah.
Yeah,
At 6 a.m. when we got the list.
Okay.
it's not a unheard of thing. But
I don't know, I just answer questions. All right, see you.
Do you happen to know if Hansen was down there?
What?
Do you happen to know if Hansen was down there?
transfer list.
Okay.
Huh?
Caitlin is still pizza.
I'm sure if I had to, it would be anything, but no, nobody loves you like she does. Nobody like she does. Your other stuff.
This one I like.
I know. So you see, you can trade it up.
Nathaniel, who's winning?
You said what?
Who's winning?
Oh, they were up by 11 at halftime. Michigan State.
Say, you gotta give us updates.
All right. And Duquesne is beating BYU.
Nice. Virginia got smoked. Did you watch that game?
They might have been the worst basketball team I've ever watched this entire season. They looked awful.
Like so bad. They had a lot of injuries though. I think they've got like some of their walk-ons.
They went 57 minutes of real time without scoring.
It was so
That's
bad.
insane.
It was so bad. When I saw that it was like they had 14 points at the half, I was like, oh.
Yeah.
It's gonna be one of those games.
Actually, MSU's up by 7 at halftime, not 11, my bad. But yeah, no, that was terrible. If it was 50, we probably should be in the tournament.
Yeah.
I'm just trying to make sure I'm doing everything right. I'm not saying one part of it. Trying to make sure. No. Go through the, may I say something? I'm not gonna lie. This is scary work, so, taking in and making sure I do any and everything right, that's all I want to do. I make sure I park my everybody. I don't get no BS, I don't go.
Ms. Wilson, how are we, Mr. Ream?
Yes.
All right, so we're on the record in docket 24-00633. That's people of the state of Michigan versus Matthew Ream. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Ream.
And sir, you are Matthew Ream, is that correct?
Sure.
All right, thank you. This is time set for a preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that we're going to proceed with the examination today.
All right. Are there any pretrial matters or preliminary matters to come to the court's attention before we get started?
Just the typical sequestration of witnesses.
All right. And Ms. Robinson, I'm assuming you want the sequestration of
Correct.
witnesses, so I'll leave it to the litigants to let me know if any witnesses come in that should not be present and watching another witness testify. With that understanding, Ms. Wilson, you may proceed.
Thank you, Your Honor. The people call Officer Thackeray.
All right, Officer Backer, you can come up here. Please face me and spell and state your first and last name for the record.
Jamel Bakri. Spelling is Jameil. Last name's Bakri.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
Yes, I do.
Okay, go ahead and have a seat. The microphone is for recording purposes for the court recorder. So please project as best you can.
Okay.
Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Thackeray, are you currently employed?
I am.
And where are you employed?
Lansing Police Department.
What is your job title?
Patrol officer.
What are your general duties?
Respond to calls for service on patrol.
How long have you been a police officer?
Just under 5 years.
Now I'd like to bring your attention back to March 5th of 2024. Were you working on that date?
I was.
What were you wearing on that date?
Full police uniform.
And does that have designation of police on it somewhere?
Yes.
Okay. And did you have occasion to respond to a call at 601 North Larch Street?
I did.
Is that in Lansing?
It is.
Ingham County?
Yep.
Michigan?
Yes.
And what was that call in reference to?
Two subjects fighting inside of the homeless shelter located there.
All right. And when you arrived, did you make contact with anyone?
I did.
Who did you make contact with?
Matthew, I'm not sure how to pronounce his last name.
Okay. Did you get a good look at this person during your interaction?
I did.
Do you see him here today?
I do.
Can you point him out and describe something he's wearing?
He's wearing a blue jumpsuit.
Your Honor, I request that the record reflected identification.
Any objection to the witness identifying the defendant for purposes of prelim, Ms. Robinson?
No, Your Honor.
Without objection, the witness identified the defendant for prelim. You may proceed.
Thank you, Your Honor. And Officer Thackeray, when you made contact with Mr. Ream, what happened?
He was in a verbal altercation with one of the staff members. My partner, Officer Hyatt, began telling him that he needed to leave. I observed him not do that, despite her multiple commands to do so. So eventually we took him to custody.
Okay. And after you took him into custody, what happened?
We walked him out to the patrol vehicle to the rear passenger side. I held on to his left arm while Officer Hyatt conducted a search incident to arrest.
And was he saying anything while this was happening?
He was.
What was he saying?
He was saying he didn't give a fuck, that he was gonna fuck me up, he was gonna put me down, and various other things. He called me a nigga. I thanked him for not putting the ER on the end of it, and then he began calling me a nigger instead. And he continually turned towards me. So because of the things that he was saying, how he was being, I asked him to face towards the patrol vehicle so that I didn't get spit on or headbutted. especially with the threats that he was making towards me. He did not listen to that. I attempted to force him to face towards the patrol vehicle. He pushed against me, resulting in us me escorting him to the ground to control his body movements.
And so just for the record, what is your race?
I am black.
Okay. And did you feel that those slurs were being directed at you specifically?
Yes.
Okay. And did you feel that that was because of your race?
Yes.
Okay. Now, during this interaction, were you wearing your department issued body camera?
I was.
Was it operable at that time?
It was.
And at some point, did you turn it on?
Yes.
Okay. Here. Permission to approach, Your Honor.
You may.
I'm handing Officer Backery what's been labeled as People's Proposed Exhibit 1. Do you recognize that?
Yes.
And what is it?
It is a flash drive containing my body cam footage.
Okay, and have you had an opportunity to review it?
Yes.
Is it a fair and accurate representation of what occurred on that date?
Yes.
Okay. Your Honor, at this point, people would move to admit Exhibit 1.
Any objection to Exhibit 1 being admitted?
No objection.
Without objection, People's Proposed Exhibit 1 is admitted into evidence, and you may publish.
Thank you, Your Honor. Second again to get reset up. I'm just gonna jump ahead a bit here.
Never pushed against you. You bang pushed the knife on me.
So Officer Backery, at this point, is this when Mr. Reams being detained?
Yes.
Okay. And for the record, I'm at minute 2 and 53 seconds.
You want to fucking arrest me? Man, get the fuck out of my face. Bart, here we go now.
Oh, we about to.
You got to put the handcuffs on? Good.
Well, there they are. So just gotta make sure they're not too tight, bro.
Too tight. I had to break my wrist to get them right.
Okay.
All right.
There you go.
All right, let's go.
Oh, fucking play. You'll find out today. You on your way, huh? Oh, you was on your way. You must have known I was in the county. Fuck out of my way. You gotta have some special surgery. You gotta get my shit. My bags. And my bag. Get my bags. I ain't done nothing wrong.
Well, she told you to leave. You didn't leave, bro.
I did leave.
You didn't.
Man, get the
We had to
fuck-
walk you out.
Shut up. I'll plead the fifth. Shut up. Talk to
No,
me.
we need to do something first.
Shut up. Talk to me. I'll plead the fifth.
That's fine. Yeah,
I don't
sure
give
can.
a fuck, man. Don't manhandle
here,
me,
okay?
man, 'cause I'll fuck you up.
Stand
You
here.
understand? Resisting with me?
I'm telling you to stand
I'm
here.
standing here right now. I'm telling you right now. You fuck with me, I'll put you on the ground.
Face the
Out
car,
the
please.
cuffs.
Face the car,
Face
please.
down.
Face the car, please.
I will tell you right now.
Thank you.
You know
Face
right
the
now.
car, please.
So you know.
My man, I'm trying to be nice.
So
to
you
guy.
fucking know.
Face the car. That's all you gotta do.
You motherfuckers.
Say whatever you want, but face
I
the
don't
car,
say what I
okay?
want. I say what I am.
Okay, that's fine.
Bitch, you no fucking. Get your arm off me, man. I'm getting in the car running.
I can't do that,
You
okay?
can't do that. I'm getting
Just
in the
stay
car.
still, okay?
I can't do that. I just want. So what do you want to put on me? Resisting?
I don't want.
Is that it?
But I need you to face the car. If you
I'm
don't stop
trying to
facing
get
the
in
car,
the fucking
you're
truck.
gonna get put against the car.
Get me in the truck.
Okay, this is your last warning.
This your last warning.
Again, you're going
Last
to the car.
warning, motherfucker. You ever warn
Face
me
the
again?
car.
Fuck. Warn before they lose their life and breath right now. Say something again. Say something again. Threaten me again.
Face the car.
Threaten me again. Threaten me again. Threaten me again, motherfucker.
Face the car, please.
Threaten me again.
You have any needles on you? Anything
You take your breath in life. You're gone. You'll never see tomorrow. Hey, I hope you got kids. It'd be all right though. The family needs them more than they need you. So, nigga, bye.
That's rude.
No, you a nigga.
Okay.
It ain't rude. It's the
At least
truth.
you didn't put the ER
It's
in
the
there.
truth, nigga.
Oh, damn. You had to put the
Bro,
ER in there?
I had to
That's
tell you the
fucked up,
truth.
bro.
But what's fucked up is that you think you're
Stop
tough,
leaning
man.
back. Stop leaning back. That's,
You know,
don't do
'cause
that.
I'm like, oh, I'm leaning, and he's like, oh, he's hurting, he's resisting. There we go. I ain't done nothing to resist. I'm trying to.
You ain't strong enough, bro.
I'm trying to get in the car.
Stop. We're not
I'm
doing
trying
that.
to get in the car.
We're not doing that. Go ahead, keep searching them unless you're done. We ain't
What,
doing
you
that,
want to
bro.
push my head into the concrete?
Not at all, sir.
Oh, you got
But
lawyers?
if you stay still,
I got
still,
him.
it won't happen.
Oh,
I don't
got
even have your
lawyers.
head against
They're
the
watching
cement right
now.
now.
Did you know who you? Did
Stay
you know
there.
you my name?
Stay there. You gotta stop.
Hey, man, get the fuck out of here.
All right.
You
just gotta
stop
stop.
first. You wishy-washy wanna be.
You gotta stop trying to push against
I
us.
ain't never pushed against nothing.
You did. You're tensing up
I
your
ain't
arms,
never,
pushing, leaning
never
back
pushed
into it.
against you.
Calling
Never.
Calling me a nigger?
Get him off
That's
me,
messed up,
nigger.
bro.
Cause you a nigga, so you took it to the heart. That makes you lesser than somebody. Cause you took it and it made the opinion affect you. You fucking wishy-washy wanna be.
All right, that's fine.
Come on, Pup. Get me up out of here.
We will. When
We
we're
gotta
done.
go. Get him
Stay
off me.
here. Stay
Get him
here.
off me. Get him off me,
Stay
father.
here.
Get him off me.
Stay here.
Right now. Get him off me. You
Stay
can't
here.
push my head to the ground. What do you want to push my head into the ground? You want to push my head? You want to punch me in my face?
Do not hit me.
You hit me.
Do
In
not
my
hit me.
face, motherfucker.
We are sitting here just fine before
You
you start
pushed-
doing that extra
You
stuff. Stop.
punched me in my face. You weak ass
got his
bitch.
I got his legs.
Oh, you punched me in my face.
Yeah, I did.
Yeah. It's on.
Don't try to knee me.
It's on.
You didn't try to knee
Let's
me.
go.
You'll be fine.
Let's go. Hey, it's on camera.
Yeah, I know.
Bitch.
That's fine.
You nigger.
Okay.
You hit me.
I'm a nigger today.
You
I'll be a
got
nigger
pay for
tomorrow.
this shit. You do, don't you? 'Cause
Relax.
I got attorneys out of fucking every state.
That's fine.
You can't
Relax.
take it off. Get me up if you break my shit.
Relax.
Get your fucking hand
You
off
can
my
relax. I
face.
can do that.
Right now, father.
If you relax and stop
I'm gonna
tensing your
fuck
body.
you up.
That's not
You're not
gonna
gonna breathe again in a second.
happen. Okay.
Well, get my people come through.
Okay. If
Oh,
you stop,
know.
I can let
It's
you
okay.
go.
I'm done. Stop. Can you let me go? Look at the fuck you push me in the face. Who does that?
And if you
Who does
hit
that?
me again, I'm gonna do it again.
You gonna do it again or punch me there, you bitch ass motherfucker. Punch me again. You weak ass. You punched me.
Ready?
You punched me, you
Got the other side, or we
motherfucker.
need to search the other
Get him
side?
away from me. Get him away from me now,
Do we
sir.
need to search the other side or we good?
Get him away from me.
We're good? All right.
Get him
you
away
grab
from
that
me.
other arm.
Get him away
We're
from
gonna
me.
go straight up, okay?
Get him away from me. Get him away from me.
There you go.
Fuck
Get the
away
car.
from me. Get the bitch ass. Stop. What?
Stop
You
doing
want
that.
to get some?
You got him.
Ain't nothing between you. It's between me and him. Get some.
There you go.
Fuck out of my face.
Move your leg. You got him. Go there.
Go ahead and pause at minute 8:41. So Officer Backery, when Mr. Ream was getting into the car, it looks like he made some kind of movement. Can you describe that a bit?
When he was getting pulled into the car from the other side,
Yes.
he just kicked his legs outward.
Okay, and did that make contact with anyone?
I don't believe so.
Okay. While he was in the car, do you know if he was making any other statements?
I couldn't hear what he was saying.
Okay.
He was hitting the partition while he was back there, and only contact I had while he was in the back seat was I told him to stop, otherwise I'd have to sit back there with him.
Nothing further for this witness, Your Honor.
Cross-examination, Ms. Robinson.
Yes. Good afternoon, officer.
Hello.
All right, so you stated that the call was for two subjects that were fighting.
Correct.
Okay, and when you spoke to Mr. Ream, how did he appear at first?
In regards to what? Like how his actions?
Right, like what was his demeanor like?
He was upset.
Okay, so when you arrived at the shelter, he was already upset at that time?
Yes.
Okay, he was clearly being belligerent.
Yes.
By the time that you arrived.
Correct.
So he's already upset. And then at that time you attempt to ask him to leave,
Yes.
correct? And he refuses to do so?
Yes.
Okay, and that's when you and the other officer involved, I forget her name, I'm sorry, attempt to take him outside, correct?
He's detained he's placed under arrest inside of the.
Right,
Flowers, but
and
yes,
then you take him outside while he's under arrest.
Yes.
He's handcuffed at this point.
Yes.
And I saw in the body worn camera footage that there's you, the female officer, and is there also another male officer as
Yes,
well? Okay, so there were 3 officers total.
Yes.
All in police uniform at that time.
That's correct.
All with their standard issued firearm, correct?
Yep.
Okay. And so when he is outside and he starts making these racial slurs towards you, he's already in handcuffs at this point.
Yes.
Okay, and the 2 other officers are also with you at that point.
Yep.
And so you stated that he was kicking his legs out towards you, but being pulled in by the other officer from the other side when he was in the back of the car?
Once he was being placed in the patrol car.
Yes.
Yes, I don't know if they were towards me. He just kicked him out.
Sure. I guess so was he being pulled in beforehand or was it like all at the same time?
It was kind of simultaneously.
Okay. And when he was brought to the ground, you obviously had to use force against Mr. Ream, correct?
To escort him to the ground, yes.
Okay. And what exactly, what technique did you use to do that?
It would be a straight arm bar takedown, the move from that. However, obviously his hands are behind his back.
Okay.
So the same motions, but with my arm underhooked under his left arm.
And after he was subdued and placed in the vehicle, did you notice any sort of physical injuries on Mr. Ream?
Yes.
And what were those?
He had a bloody lip.
Okay. Anything else?
Not that I can recall.
Do you know if he sought medical attention or if he was taken to a hospital?
He was not.
Did you take any pictures of his face or the bloody lip?
I don't recall.
Do you know if any other officers did?
I don't believe so.
Nothing further.
Any redirect, Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people,
He may, Your Honor.
from the defense?
Yes, Your Honor.
All right, you're all set, officer. Thank you for your briefs. You may call your next witness, Ms. Wilson.
Thank you. The people call Officer Hyatt.
Officer Hyatt, you can step right up here. Please stand right in front of me and state your first name and your last name for the record.
Haven Hyatt, H-A-V as in Victor, E-N, H-I-A-T as in Tom.
Okay, please raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, have a seat. The microphone is for recording purposes. Please project to the back as best you can. Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Hyatt, are you currently employed?
Yes.
Where are you employed?
Lansing Police Department.
What's your job title?
I'm a police officer.
And what are your general duties?
I serve the public by taking calls of service.
Okay. Were you working on March 5th of 2024?
Yes, I was.
And what was your assignment that date?
Patrol.
What were you wearing?
A fully marked Lansing Police Department uniform.
Okay. On that date, did you have occasion to respond to a call at 601 North Clark Street?
I did.
Is that in Lansing?
It is.
Ingham County?
Yes.
Michigan?
Yes, ma'am.
And what was that call in reference to?
Is in reference to a white male attempting to fight other people inside of the homeless shelter.
Okay, and when you got at that location, did you make contact with anyone?
I did.
And who was that?
Matthew Rain.
And did you get a good look at this person?
I did.
Do you see him here today?
I do.
Can you point him out and describe something he's wearing?
He is wearing a blue shirt.
Okay. Your Honor, for the record, I'd like to reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim?
No, not for purposes of prelim.
With that understanding, the witness has identified the defendant.
Thank you, Your Honor. Officer Hyatt, so once you made contact with Mr. Ream, what happened?
I advised him that he was supposed to be leaving the building for outreach staff, and he continued to ignore my commands.
Okay, and after your initial telling him that he needed to leave, what happened?
He began advancing towards other people, refusing to grab his items and leave the building. I advised him to stop multiple times and he ignored my commands. I eventually had to take him into custody inside of the outreach because he would not leave.
And after you took him into custody, or let me back up. What happened as you were taking him into custody?
He kept pulling his arms back, and I had to have 2 other officers assist and take him into custody before I could place him in handcuffs.
Okay, and after he got into custody, what happened?
We took him to the patrol car and he stopped pulling away from us, and we eventually had to escort him down to the ground to maintain better control so I could conclude my search before putting him in the patrol car.
Okay, and once you were bringing him into the patrol car, what happened?
In the patrol car, he was refusing to get in, and a different officer had to assist with helping him into the vehicle.
Okay. Nothing further.
Cross-examination, Ms. Robinson.
Good afternoon, officer. So you testified that during this incident, you were called in for a command because there was a possible fight going on at the shelter, correct?
That's correct.
Okay, and when you arrived, you were in full police uniform.
Yes, ma'am.
So how would you describe Mr. Ream's demeanor when you first saw him?
Aggressive, pacing back and forth, yelling at other people inside of the shelter.
Okay, and so this was going on as soon as you entered?
That is correct.
Okay, so it's fair to say that his demeanor wasn't caused by you or the presence of an officer?
No, not to my knowledge.
Okay, now, you asked him to leave the building, correct?
I did.
Okay, and he refused to do that, and that's when he was handcuffed and detained.
That is correct.
Okay, and at that time, you took him outside to where the police vehicle was.
That is correct.
Okay, now then there was a time when he was taken to the ground. Why exactly was he taken to the ground?
We told him to face the car. He kept not facing the car and he kept trying to pull away. Officer Backery escorted him to the ground to maintain better control over him.
Okay, and where were you in regards to where Officer Backery was?
Officer Backery was on his left side. I was directly behind.
Okay.
Yes.
So within arm's reach of Mr. Ream?
Yes.
And he was taken to the ground. Did you notice any injuries on Mr. Ream because of that?
No, not at that time.
Nothing further.
Thank you. Any redirect, Ms. Wilson?
None, Your Honor.
May this witness be excused from the people,
She may, Your Honor.
from the defense?
Yes, Your Honor.
All right, thank you for your appearance today. You're excused.
Thank you, sir.
Any additional proofs, Ms. Wilson?
None, Your Honor. The people rest.
All right. Any proofs today, Ms. Robinson?
No, Your Honor.
Motion for bind over, Ms. Wilson.
Thank you, Your Honor. The defendant is currently charged with 2 counts of resisting and obstructing a police officer. Based on the testimony here today, both Officer Backery and Officer Hyatt responded to a location within Lansing, Ingham County, Michigan. They were in full uniform. They were clearly in their active duties as police officers. So the defendant knew or should have reason to know that they were police officers. Additionally, I believe based on the footage and his statements to officers, it's pretty clear that he knew that they were officers acting in their official duties. During this time, Officer Backery and Officer Hyatt both testified that they gave him commands lawfully under their duties as police officers, and Mr. Ream refused. Additionally, Officer Hyatt testified that Mr. Ream pulled away from her and tried to resist being put into handcuffs. Officer Backery testified that Mr. Ream had to be taken to the ground because he kept pulling away from him. And as you saw in the footage today on body cam, Mr. Ream did attempt to kick the officers. So I believe for a probable cause standard, the counts of resisting and obstructing have been met. Now, at this time, the people are also seeking to add an additional charge of ethnic intimidation. During this assault, Mr. Ream used a number of racial slurs directed specifically at Officer Backery, who is as he testified here today, a Black man. And as he was making these racial slurs, he was attempting to make contact with Officer Backery, and he was making threats of making contact with Officer Backery. And while he was in handcuffs, as could be seen on the body cam footage, he had free use of his legs during this time and could, in fact, make contact with Officer Backery if Officer Backery had not moved out of the way. And this appeared to be intentional, directed Officer Backery in attempt to get a rise out of Officer Backery. So at this time, we would be requesting bind over, as I believe the probable cause standard has been met for ethnic intimidation.
Thank you. Response, Ms. Robinson.
Yes, Your Honor. As to the charge of ethnic intimidation, it's 750-147B in the penal code. So it states that a person is guilty of ethnic intimidation if that person maliciously and with specific intent to intimidate or harass another person because of that person's race, color, religion, gender, or national origin, does any of the following: causes physical contact, destroys, damages, or defaces property, or threatens by word or act to do something in A and B. What was given in testimony today was that the officers arrived. When they arrived, he was clearly already upset at something that had happened at the shelter, and that it's clear that he was already clearly upset when they arrived. He was acting belligerent in that, prior to the officers getting here, they arrive, that doesn't change. He's taken outside and then he's detained, and he's detained in handcuffs. He does say some racial slurs in the body worn camera video. However, I don't think it was done with the intent to intimidate or harass the officer in this case. I think he's clearly upset. I don't think he's doing anything to specifically necessarily cause like physical contact with the officer or to threaten that physical contact with the officer. He's upset that he's being arrested. He's upset at that situation, and he's been upset. He was upset prior to them being there. So I don't think that the ethnic intimidation charge would apply here.
Thank you. Response, Ms. Wilson.
Yes, briefly, Your Honor. I would just point out that under People v. Shutter, the ethnic intimidation statute does not limit these cases where the specific intent to intimidate or harass is the only reason for the criminal act. The statute is satisfied as long as the specific intent is made prior to the criminal act. Here we see a number of occasions where Mr. Ream is resisting the officers, and in the course of resisting, he's making these slurs. He's directing them at Officer Backery. He's threatening to make contact. He even makes threats to Officer Backery's possible children. It's pretty clear that there was a specific intent here to harass Officer Backery because of his race. So I would request bind over.
Thank you. All right, so in regards to the standard for probable cause is this is a preliminary examination. Preliminary examination has a probable cause standard. It's the second lowest standard in criminal law. I find that based on location, venue, ID, and date from the officers, Jamil Backery and Haven Hyatt, that count one has been met. That commonly referred to as resisting and obstructing, that the defendant, Matthew Ream, did an assault, batter, wound, resist, obstruct, oppose, or endanger Officer Haven Hyatt, a police officer of Lansing Police Department. The defendant knew or had reason to was performing his or her duties. That is based on both Officer Haven Hyatt's testimony and Officer Jamil Backery's testimony concerning they went into a situation where the defendant was already upset. They brought him out, and he resisted. They wanted to get him in the truck, and he resisted getting in the truck. There does seem to be some indication that he moved forward, that he kicked out, that he refused, that he was refusing or resisting to get in the truck or any orders of incarceration at the time. So I find count 1 has been met pursuant to exhibit 1 in the testimony and the video that was played. In count 2, did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jamil Bakri, who also testified. Police officer of the Lansing Police Department, that the defendant knew or had reason to know was performing his duties in relation to the same Officer Hyatt and both Bakri both testified, and the exhibit indicated that there's probable cause to believe that the defendant was guilty of R&O as stated by the court in count 2. So I'll bind over on that. And then there's a requested count 3 of ethnic intimidation. That's really the more interesting of the bind over request. That's a new count, and that's a 2-year felony and or $2,000, I believe. And there's case law to indicate that it does, as represented by counsel, it does not have to be the sole factor. It can be one of factors that would lead, based on the conversation. There's no doubt that this conversation is led to resist, wound, intimidate an African-American officer. I mean, I don't think that how the African-American officer dealt with that is his own personal subjective nature that always does his job. But there's plenty of case law on this. There's People versus Shutter. The Court of Appeals held racial animosity did not have to be the initial or sole motivating cause of defendant's actions. Even though road rage appeared to have started the confrontation between defendant and the victim, defendant's subsequent use of racial slurs while beating the victim was sufficient to sustain a conviction. And in People versus Stevens, the Court of Appeals held the defendant used the word nigger together with his reference to the complaint as a black bitch. His statements that you people shouldn't be allowed in here and his attempt to punch the complainant was sufficient to provide the evidence of maliciousness and specific intent to intimidate, harass because of race. It would appear that the conversation that takes place, conversations to racial slurs specific to Officer Jamil Bakri, and then his response to that, which is that as a part of this in custody relationship and statements, seems to be directed at the officer because of his race. And that would suffice at a probable cause level, the ethnic intimidation charge. So the court will bind over his charge on counts 1, 2, and the amended count 3, or the added count 3 of ethnic intimidation. And if correct me if I'm wrong, that is a 2-year and or $2,000 felony. Is that correct?
It is a 2-year. Let me double check on the 5,000.
5,000. And what's the PAC code for that?
Yes, 1.
750.147B.
That's correct.
Okay, 750. So I find probable cause to bind over on all 3 counts at issue in the case. And so your next, Mr. Ream, your next date in court will be in circuit court from Ms. Robinson, your attorney, that you'll get that date within the next 2 weeks. In your circuit court date, this case is bound over as charged with the addition of count 3. Your time in district court is done. You're now going on to circuit court. Anything else for the record in docket 24-00633, Ms. Wilson?
Not from the people.
Ms.
No, Your
Roberts. Okay, thank you. That's all for the record in that file. Thank you, everybody, for your appearance.
Thanks.
If Mr. Officer. Maybe begrudgingly, yes.
For the record, maybe
Added count 3 of ethnic intimidation. Sometimes they're- Well, Ms. Robinson, I don't get to see you that often, so it's nice to see you again.
Thank you.
You're on to bigger and better things.
Oh, I don't know about that.
Well, us Austin, you're here on Hibbett.
Yes, sir. So, do you need one real bad?
What was your guy's name? Jared?
Hawks.
Hawks.
Yeah.
Yep.
I already sent out an email earlier, so somebody may be there and beat you to it already. but
No worries.
I wanted to make sure.
We'll get it done. I'll make sure it's done.
Appreciate it.
Yep.
That John Michael message. Which is fine.
I'm trying.
I get to go to it, but I don't.
Wasn't planned to be here that long.
No, the last update I got from Daniel was states up.
My wife said that they were up by 8 at halftime.
Confirm that Hanson was downstairs. Okay.
Hanson and Hibbett, right? And we're bringing up Hibbett? Okay.
Yes. And then we should be done.
No, that's fine.
Hibbett is a little on the angry side.
Oh, great. But I don't have any exhibits for this one, Wendy.
You know.
That's not fun. We had a 2.5, I'd say about a 2.5 hour hearing yesterday, in which the plaintiff's attorney yelled at his client off the record, you know, but I knew you could see it happening, that he's kind of a high-strung fellow. His client would not leave him alone, and she was kind of high-strung. And finally he'd had it, and he said, like, you gotta stop, you gotta leave me alone. I mean, it was the hardest I've had in keeping a judicial demeanor, because I really wanted to laugh, because he just had it. He'd had it with his client, because, you know, and she was paying him to look over his shoulder, and he didn't want it. So it was kind of and he wasn't young either. I mean, he's been around that attorney, and I know him, so you could just tell he was getting like, you gotta stay away from me. He's just, and she didn't.
I had a few family clients when I was doing family law that I had to do that with.
All their intentions were good. The timing was bad, and he was not in the right place for that.
Like, you gotta walk away from me for a
Yeah.
minute.
You just gotta walk away from me. And she didn't want to, and so I think you just put her on the stand.
She just got off.
Yeah, she just got off the stand.
And she went to sit still, and it was driving him nuts. And then she kept talking to him while he's trying to read.
He had like 8 exhibits in front of me. He's trying to read, and she's like yelling. Like, so you just know this is a recipe for a disaster here, and it was.
One of the benefits of being a prosecutor, you don't really have clients.
No. I always welcomed, like,
absolutely.
Yeah, I always welcomed a trial when you got somebody good next to you, so they could help you with, that was very helpful.
He doesn't want the offer, huh?
I don't know. We don't talk to him. He just screams.
Just screams at you.
Oh, Mr. Austin.
Mr. Austin, I'm so sorry, Mr. Austin.
Like,
He just yells at me, what do you want? Get to the point. I want a prelim. What are we done here?
all
That's
right.
about it.
Yeah.
I get the feeling that was the nature of blood. I don't see there was a lot of discussion on some of these topics today.
I've conveyed it to him. He just does not wish to engage in conversation about it.
Mr. Austin, sometimes I think your office might be hazing you, but I'm not sure.
I don't think so.
Arson ones.
He does seem to collect a lot of unusual cases.
I think that's a good thing. I think that.
Because they know that he's competent enough to handle them. You gotta start dropping the ball a little bit.
I think de-escalation at times is the answer here. Because they're not gonna, or having the prelim,
The funny thing with Mr. Hibbert, I think the very first time I met him, he right away.
Yeah, because this looks familiar.
Oh, I mean, we just started.
Who had him previously?
What's that?
Who had him previously?
Sorry.
Oh, no, I know.
And it got dismissed because somebody showed up.
Yep.
But yeah, he's I think
Yeah.
he's just,
He said it was
he
60.
just realizes, he screwed up, they got him. So it's like,
7:35 left.
I've
A lot of time.
Yeah.
And I'd rather be up and down.
Right,
jump
Monday,
through everything.
yeah.
I saw Nathaniel still had a piece of pizza yet on his desk.
He has a cookie in there too. I actually, while he was in here, I brought him some beef jerky to eat while he was watching Independent before he got back on the record, so he had something to eat. I just can't get how it tastes. Isn't my mom that's like, I'm just trying to taste that.
Yeah, it's-
I just can't get, it's like, I ate pennies or something. That's not here, is
That's
it?
federal.
No, that's what became.
Oh, thank God. 2 more days left. I think, does he have like?
We
a
had,
business
um,
going?
tomorrow,
Yeah,
so the
is
dogs
he the
looked
one
around
that
and left
needs
in about
an
3
ASL
shifts.
interpreter
He
and
needs
a
two.
slang
He needs two
interpreter?
interpreters.
Yeah, we were talking about him
She was
yesterday.
so out.
I was like,
I get up
what?
about 3 and I let her out. And this is quick because it was cold.
It was cold.
And so I wait and then I go and open the door and she's got something in her mouth and it's screaming.
Yeah.
It's screaming like a bunny screams. I could have been like a raccoon or she's got something.
Yeah.
She looks up at me like she's playing. Shut the door because she's not bringing it down.
Why is everybody?
And I wait like for 4 minutes, 4 or 5 minutes. I open the door and then she's just playing. It's dead. It's in the building. And it's dead. And I'm like, Lola, it's time to come in. And she's like, look, this is fun. Okay. So I shut the door. I go back. Not for another hour or so. So I go back to sleep. I wake up to the dog barking. She's at the door. And she comes in, acts like nothing happens. Goes up to her bed and goes to sleep. This morning, we saw Karen's laughing.
Has Bob not sent out offers?
The dog should be outside.
I think he said.
So I said, I'm not gonna. look
Oh,
out for it,
yeah.
but I just want to work.
Oh.
Leave it with your.
I mean,
hands.
I haven't sent out offers either because I've been here. but-
Sure.
I don't know. I think it's. No bunny.
Well,
Yeah. So
at least you took care of it.
she did. She cleaned up after herself.
Thank you.
All right, so we're on the record in docket 24-00619. That's people of the state of Michigan versus James Hibbett. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Austin.
Thank you, Your Honor. Good afternoon. Jared Austin here to represent Mr. Hibbett. He is present with me at council table to my right.
And sir, you are James Hibbett, is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that we will be proceeding with the exam today.
All right. Are there any preliminary matters to come to the court's attention before we get started? I'll do a motion for sequestration. Both parties understand the case better than the court knows it at this time. And so if anybody shows up that shouldn't be listening to some other witness testify, I'll bring it to my attention and we'll address it. With that understanding, Mr. Austin, do you have any preliminary matters that you'd like to address before we get started?
Nothing additional beyond the sequestration.
All right, thank you. Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people would call Officer Clue.
Right, Officer Clue, you can come forward. I'm gonna have you stand right in front of me and please state your first name and your last name and spell them both for the record.
Christopher Clue, CHRISTOPHER, Clue, CLEW.
Please raise your right hand. Do you solemnly swear or affirm tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Right, go and have a seat in the witness chair. The microphone is for recording purposes, so please Please talk into that mic and then project to the back for as best you can. All right, sir?
Okay.
All right, Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Clue, where do you work?
I work for the Lansing Police Department as a road patrol officer,
What are your general duties?
responding to calls for service.
Were you working on March 4th of 2024?
I was, yes.
Were you, what were you wearing?
I was in my department issued road patrol uniform, driving a fully marked patrol car.
Okay. And were you on that date, on that March 4th date, were you dispatched to 906 East Shiawassee?
Yes, I was.
Is that in Lansing?
Yes, it is.
Ingham County?
Yep.
Michigan?
Yes, ma'am.
Okay. And what was that call in reference to?
We were responding to a call for a gentleman inside the laundry room of the apartment building, attempting to break into the washing machines and stealing the quarters.
Okay. And when you arrived at that address, what happened?
So as I arrived at the laundry room, I looked through the glass window of the door and I observed Mr. Hibbett inside with a makeshift metal tool, jimmying into the coin slots of the washing machines and taking quarters out of them.
Okay, and when you say Mr. Hibbett, did you get a good look at him while you were interacting with him?
Yes, I did.
Do you see him here today?
Yes, I do.
Can you point him out and describe something he's wearing?
Yep, he's sitting right there in the dark blue jumpsuit.
Thank you. Your Honor, for the record, I request that it reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim?
Without objection.
Yeah, without objection, the witness has identified the defendant for prelim. You may proceed.
Thank you. And Officer Clue, you said that he was in the laundry room, is that correct?
Yes.
And is that inside the building?
Yes, so it's within the building with the exterior door with sole access to the laundry room.
And while you were there, did you notice any signs of forced entry?
I did not.
Okay. Did you at any point have an opportunity to get a good look at the laundry machine?
I did not. Officer Vanderwerf was the one investigating that while I spoke with Mr. Hibbett.
Okay, but while you were, when you arrived, you said you saw him, like taking stuff out of the laundry machine?
Yes.
Okay, and to the best of your knowledge, was that laundry machine designed to get coins?
Yes, it was.
Okay. Now, when you said that Mr. Hibbett had a wire, can you describe a little bit what the wire looked like?
It was approximately 5 to 6 inches in length. It was a bent piece of metal with a makeshift handle. I believe it was possibly tape wrapped around one end of it.
Okay, and based on your knowledge and experience, is the method that it was bent, is that something that could potentially facilitate breaking into a coin operated device?
Yes, it is.
Now, did you, so you spoke to Mr. Hibbett, is that correct?
I did, yes.
And at some point, did you take him into custody?
I did, yes.
And did you read him his Miranda rights?
I did.
Did he say he understood them?
Yes.
Did he say that he wanted to speak with you?
Yes.
Okay, and did you ask him anything at that point?
I did. I asked him, I don't remember exactly verbatim, but I asked him something along the lines of, was your intention coming in today to steal the quarters out of these laundry machines? And he responded, yes.
Okay. That's all I have at this time.
All right. Cross-examination of Mr. Austin.
Thank you. Good afternoon, officer.
Good afternoon.
So this makeshift metal tool, as you described it.
Yes.
You said based on your knowledge and experience, that is something that could be used to tamper with such machines in order to get coins. Did I understand that correctly?
Yes, it is.
Could you expand on that a little bit? What is your training, knowledge, and experience on such tools that would lead you to conclude that?
Well, so I've personally gone through trainings on covert entry to gain access into buildings to respond for calls for service. I've also seen it multiple times in throughout my time as a police officer, people using different makeshift implements to gain access into apartment buildings through doors. And as I stated, as I arrived on scene, I saw him actively shoving the metal implement into the coin tray of the laundry machines.
And you said in this instance, you did not see or observe any signs of forced entry, is that correct?
I did not.
Were you ever able to determine more precisely what the metal tool was?
I was not. Officer Vanderwerf was handling the bag of tools that he had along with the implement that we observed him using.
And you said you had initially observed what was going on before making entry into the laundry room, is that correct?
Correct, yes.
How long did you make that observation before going in?
Approximately 10 seconds. I was waiting for my backup officer to arrive. I advised him what was going on before we went in and made contact with Mr. Hibbett.
And approximately what time was this?
I don't recall exactly.
You know, if it was morning, night, daytime, dark?
It was probably about mid-evening, I would say.
Still light out?
It was probably dusk. It was getting dark.
And you said you had an occasion to speak with and interact with Mr. Hibbett, is that correct?
Yes.
Okay. And do you appear to be under the influence of anything to you?
I can't say definitively. I'm not certified to say if someone's intoxicated or not.
Did you observe any signs of that would indicate that?
Not that I can say.
And after the brief questioning you did with Mr. Hibbett, is that where your involvement with him in this case essentially ended?
Yes, so I assisted in getting him to a patrol car, and then I just went downtown to write my report. I didn't book him into the jail. I didn't transport him.
And you didn't search him or anything like that either, correct?
I did initial search on scene, but he was handed over to another officer for a final search before transport and booking.
Which officer was that?
I believe it was Officer Childs and Officer Wynn.
So overall, how many officers ended up being on scene?
Four in total, yes.
I think it's all the questions I have.
Redirect, Ms. Wilson.
No, Your Honor.
May this witness be excused from the people?
You may, Your Honor.
From the defense?
Yes, Your Honor.
All right. Thank you for your appearance today. You're excused.
Thank you, sir.
Any further proofs, Ms. Wilson?
Yes, Your Honor. The people call Officer Lisa
When?
McGowan.
I think it's Gwen.
Okay.
Is it Officer Gwynn? Okay. Come on up here and stand right in front of me. Please state your first name and last name and spell them both for the record.
Lisa Wynn, LISANGYN.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury? Right, have a seat. The microphone is for recording purposes. So if you could speak into that and project as best you can to the back of the courtroom. Ms. Wilson, when you're ready.
Thank you. Now, Officer, where do you work?
I work at the Lansing Police Department as a police officer.
Okay. And were you working on March 4th of 2024?
Yes, I was.
Were you in uniform that day?
Yes, I was.
Okay. Now, were you dispatched to 906 East Shiawassee?
Yes, I was.
And is that in Lansing?
Yes.
Ingham County?
Yes.
Michigan?
Yes.
Okay. Now I'm going to fast forward a bit in the call. At some point, was someone arrested?
Yes.
Okay. And did you get a good look at that person?
Yes.
Do you see him here today? Can you point him out and describe something he's wearing?
He is in the gray, the white undershirt.
All right. Your Honor, for the record, I've requested it reflect identification.
Any objection to the witness identifying for the defendant for purposes of prelim, Mr. Austin?
Without objection.
Okay, without objection, the witness has identified the defendant. You may proceed.
Thank you, Your Honor. And after Mr. Hibbett was arrested, did you have occasion to assist in a search of his person or his belongings?
I did not call.
Okay. Would reading the report refresh your recollection? So.
We could just reference which report that is.
Oh, yes, I apologize. This is a report by Officer Childs, and it's case number 24519020055. Okay, and if you want to start just reading, this is page 2, just read this portion silently and then just let me know when you're done. Okay, so were you able to assist in a search of any of Mr. Hibbett's possessions or his person? Yes. Okay, I apologize. Was your memory refreshed by reading that report? Yes. Okay. Do you recall if anything was discovered either on Mr. Hibbett's person or in his backpack?
Yes, in his backpack.
Okay, and what was found in his backpack?
So I located one kitchen knife or one knife with a black handle, a clear glass pipe. And then I also located some tools. I believe there were pliers, and I believe there were also so there's pliers, and then there was what is it called?
No, at this point, I don't think so. Can you maybe give like a physical description of it?
Yep, so it's like a wrench, I believe.
Okay.
It's a wrench, but it said etc. So I don't think it's listed.
Okay. Now, how long have you been an officer?
I've only been an officer for 2 months.
Okay, and so to become an officer, did you have any sort of like academy training? Okay, and in that training, were you did you receive any training on like tools that could be potentially used in the commission of crimes? Okay, and to the best of your knowledge, are the tools that you found in the bag, are those consistent with the commission of some type of crime? What kind of crime?
So burglary.
Okay, all right, nothing further, Your Honor. And I'm just
Cross-examination, Mr. Austin.
Thank you. Good afternoon, officer. You said you've been an officer for 2 months, is that correct? And so at the time of this incident, you would have been an officer for maybe what, approximately 5 weeks or so?
Oh, I started in January. Approximately.
Okay. And you did not author your own report in this case, is that correct?
I did not.
And you listed various items that you said that were recovered from Mr. Hibbett's backpack, is that correct? You listed, I think, a kitchen knife, some pliers and a wrench, is that correct?
Yes, I also, yes.
Oh. And in and of themselves, those aren't illegal items to possess, is that correct? And there are a lot of common legitimate uses for those items, is that correct?
Correct.
And particularly pliers and wrenches, those would be items that would be frequently used certain jobs by, handymen, various tradesmen, is that correct? Okay. Would you agree with me that they have a lot of other legal uses other than for burglary, is that correct?
Correct.
And you did not witness Mr. Hibbett using those tools in any fashion on that day and time, is that correct?
No, I did not.
He didn't make any statements to you that he was planning on using those tools to burglarize someplace, is that correct?
What are you talking about?
All right, thank you, Your Honor. That's all the questions I had.
Redirect Ms. Wilson.
No, Your Honor, thank you.
May this witness be excused from the people?
She may, Your Honor.
From the defense.
Yes, Your Honor.
Thank you for your appearance, ma'am. You're excused. Ms. Wilson, any further proofs today?
No, Your Honor, the people rest.
Mr. Austin, any proofs today concerning this file?
We'll rely on the evidence presented, Your Honor.
All right, motion for bind over, Ms. Wilson.
Thank you, Your Honor. Before I begin, this is a fairly lengthy complaint. I don't know if you want me to take each charge.
I think that would be.
I think that's probably the best way to go.
So to start at one and go
Yep.
through, I think it's a 6-count complaint.
believe so,
With the
yes.
obituary.
So the defendant is currently charged with the possession of burglar tools. So today you heard testimony from Officer Clue and Officer Nguyen. Officer Clue testified that on March 4th of 2024, he responded to a location in Lansing, Michigan, Ingham County, and he observed the defendant, Mr. Hibbett, in the course of entering or breaking into a coin-operated device. Now, after he was detained, Officer Nguyen did a search of his belongings and found items such as a pliers, and a wrench. And while I agree with what I believe the defense was alluding to, that those items in and of themselves are not necessarily illegal items, I think as a probable cause standard, the context in which they were found can lead to a reasonable assertion that they were there for the purpose of some kind of burglary. So I believe that the elements of possession of burglar tools has been met by a probable cause standard. And do you want to address that one first? Do you want me to move on to the next one?
You can move on and then
Okay.
we'll cover them all at once.
The defendant's also charged with entering without breaking with intent. You heard from Officer Clue today that when he arrived, the defendant was in the building. You heard that after the defendant was Mirandized and indicated that he understood his rights and was willing to answer some questions, he told the officer that he had gone there with the intent to steal something. So I think for a probable cause standard, based on Mr. Hibbett's own representations, the elements of entering without breaking with intent have been met. He has also been charged with the carrying of a concealed weapon. Now, Officer Nguyen testified that she found a kitchen knife in his backpack that was located near his person at the time. Obviously, if it's in the backpack, it's not visible. It is a weapon that can be potentially a dangerous stabbing weapon that can be used dangerously. So I believe for probable cause standards, the concealed carry of a weapon has been met. The defendant has also been charged with a larceny in a building. Now, when Officer Clue arrived at the building, Mr. Hibbett was in the course of stealing coins from a machine. Clearly they were not Mr. Hibbett's items because they were in the machine. He was forcing his way into the machine, so I think that there's some circumstantial evidence there that he was not taking those with the consent of the owner. Finally, or not finally, sorry. Next, Officer Clue testified that this occurred in I believe he said, like the basement or the first floor of a building. So I believe that element has been satisfied as well. There was some movement of the property. The coins were in the machine and then they were taken out of the machine. And the coins of themselves have some kind of value. And based on Mr. Hibbett's representations that he intended to steal the coins, I think it can be inferred that he intended to permanently deprive the owner of those coins of those coins. So I think the elements of larceny in the building have been met by a probable cause standard. He has also been charged with the breaking and entering of a coin-operated device. Now, Officer Clue testified that the laundry machine appeared to be a machine that was intended for the reception of coins. And as he got to the location, he actively saw the defendant in the course of breaking into the machine. And again, by Mr. Hibbett's own statements, he was there, he intended to take the coins from the machine. So I think there's a probable cause standard of breaking and entering a coin operated device. Finally, he has been charged with possession of a device for breaking and entering of a coin operated device. Officer Clue testified that when he arrived there, Mr. Hibbett was using a wire that was bent and appeared to be, as he was using it, it was being used in a manner to get the coins out of the machine, to break into the machine. So I think there's a reasonable a reasonable implication there that the device was in fact intended to break into the machine, and it was fashioned in a way to permit Mr. Hibbett to do that. So I believe a probable cause standard has been met for that charge as well. And I would request bind over.
Response?
Yes, Your Honor, thank you. There may be very well some fact questions on some of the issues here that would left be suited for trier fact. However, some things that I want to point out, Your Honor, specifically as it relates to the possession of burglary tools, where it appears that the people's position that the tools that he was in possession of that were described here today, which were mainly limited to pliers and the wrench. I think what the law says and the jury instruction says that one, they have to be adapted and designed for breaking and entering. Certainly they may be capable of being able to be used in that fashion, but I don't think those common tools that were described would be adapted and designed for breaking and entering. I think the adaptation and the design of them are for common legal uses, to be used in works projects or by tradesmen or various things around the house. So I don't think that they quite meet that element there, because it wouldn't be, those tools described wouldn't be adapted and designed for breaking and entering, regardless if they could be used for that, or even in fact that they were going to be used for that. Certainly in this case, it does not appear that there was. As the officer testified, there was no evidence of any type of breaking or forced entry. There wasn't any testimony from anyone that Mr. Hibbett made any type of statements that he had those tools specifically for using them, either in that instance or for some other future instance for in some type of burglary or breaking and entering, which is also, I think, the final element that they have to show that it was intended to be used for them to break and enter a fill in the blank. So I really don't think they've met their burden as it relates to that. As it relates to the remainder of the charges, Your Honor, I would oppose the bind over, and I would ask the court to dismiss those charges at this time.
Thank you. Ms. Wilson, response.
Thank you, Your Honor. As for the tools being adapted and designed, I think that the tools in and of themselves are fashioned already in a way that can be designed to break into something. So I would request that the bind over on that. And as to the intent to use them to break and enter, there was testimony here today. And I think within the context of the situation that Mr. Hibbett was at that location, he was in the course of committing a larceny in the building. Whether or not he got there and he actually needed to use those tools to get into the building is not necessary for the offense. It's just whether or not he intended to use those to get into the building. And I think there's a reasonable inference that he went there believing maybe that he needed to break into the building, and then he got there and he didn't, so he didn't need to use the tools. So I think there's a reasonable inference there that he intended to use them as burglary tools. So I would request bind over.
Thank you. So the standard for preliminary examination is probable cause. The court finds location, offense, venue, ID, and date have been made, and then I'll go through each count. I find as to count 2, breaking and entering without breaking, count 2 is bound over. So preliminary exam held. And count 2 is bound over. As through the own remarks of the defendant, did without breaking into an apartment building located at 906 East Shiawassee Street with the intent to commit the crime of larceny. Mr. Hibbett pretty much said that to the first officer who testified. That is Officer Clue. And I think the elements of that crime have been met by a probable cause level in regard to location, offense, venue, ID, and date. Count 3, both Officer Gwynn. Officer Gwynn. Is count 3 indicated that she was, after her memory was refreshed, observed a knife in the backpack, which would meet the elements for did carry a weapon, to wit, a knife concealed on his person pursuant to the statute, and therefore count 2 and 3 are bound over as charged. Count 4, based on some of the representations of Mr. Hibbett, indicating to Officer Clue that he was in the building to steal. He was actually observed taking from the coin-operated device, which would indicate that this is larceny in a building. So count 4 is bound over as charged on probable cause evidence. Count 5 is the forced entry or alter and insert a part of an instrument into a device designed to receive currency or coins, to it a coin-operated lottery machine. That was actually observed by the officer as he stuck a metal wire in there to get some quarters out of the coin-operated device. I believe that has been proven by probable cause evidence and will be bound over. Count 6, it's one or the other, and I think that count 6 is the more definitive and accurate indication of possession of a device to open a coin-operated, and that he had a wire that was fashioned to enter into the machine and somehow get quarters from the machine that he was observed doing. So I'm going to bind over on counts 2, 3, 4, 5, and 6. Count 1 at this time, possession of the burglary tools. There's some question as to whether they were adapted or designed. They are type of tools on their face for a burglary possession. They're also meant for additional purposes, obvious purposes. So I don't think the burden has been met by probable cause for burglary possession tools. I do believe the possession tools he had was in regards to getting into the coin-operated machine that was the previous count 6. So I will bind over on counts 2, 3, 4, and 5, 6, and I will deny bind over on count 1. So the court binds over as charged on counts 2 through 6 and dismisses count 1. Anything else? So your time in district court is done, Mr. Hibbett. You'll be on to circuit court to face the trial on counts 2, 3, 4, 5, and 6. You'll get your next date from your attorney, Mr. Austin, concerning your arraignment in circuit court. Anything else for the record in 24-00-619, Ms. Wilson?
Nothing, people.
Mr. Austin.
Just one moment, if I may, Your Honor. So. Your Honor, if I could address the issue of bond.
You may.
I know on its face, it probably appears that Mr. Hibbett's bond is relatively reasonable and low. And it is, looks like it's 3,000, 10%, it's $300. That's $300 Mr. Hibbett simply does not have. I would note that the court denied bind over on count 1, which was a 10-year felony. That was the most severe charge that Mr. Hibbett was facing. Now the most severe charge he's facing is a 5-year. He informs me that he would be living here locally. I think hopefully the court would be persuaded that that would entitle him to some type of bond reduction that he could post, given that perhaps personal recognizance release, Your Honor, as long as Mr. Hibbett complies with timely check-ins with pretrial services and so forth. These are non-violent offenses in nature, Your Honor.
Thank you, Ms. Wilson.
I would think it's your honor's discretion.
Yeah, I will review bond, and I have reviewed bond in anticipation. There's a fourth offense notice on here that equally home invasion second, B and E a coin op, B and E a coin op. So at least 3 priors. I'm not convinced that bond should be reduced at this time. So bond remains the same at 3,010%. Anything else for the record, Ms. Wilson?
Nothing from the people.
Ms. Roston?
Your Honor, thank you.
Thank you.
Welcome, sir.
That's all you can request as attorney is you tried.
Yeah.
Yep, you tried. Yep.
Far different tone and look so that we.
That's good. There-
Sometimes they just need to see you actually, make
Yes,
this happen.
yeah. Yeah, you're developing trust, Mr. Austin.
We'll see how long it lasts.
Yeah.
All right, so we have.
I did try.
You did. You did. Yep.
Did you sign the transcript request?
I did.
I don't think I did. Yeah.
Very good.
I'm trying not to lose paperwork today.
Modicum of success.
I think that was fair.
For given what the facts were, that's about as best as
I think that was fair.
I charged that and I went back and forth on the burglary tools and I was like,
Yeah.
I think I have an argument. Let's take it.
It's
There we
there,
are.
it's there, it's there,
Yeah.
but you got to go one way or the other, I
Yeah.
think, so.
Yeah.
but
Thank you.
He's got enough stuff to worry about.
Yes, absolutely.
He doesn't walk away empty-handed.
No,
All right, thank you, Judge.
thank you, Mr. Austin.
I think you are.
They won.
Yeah.
For those of you who are interested, Michigan State won.
Aha. By how much?
Just a second.
They were up by about 14, but that was a lot of time, was
69-51.
Oh.
18 points.
Thank you for doing the math, because that was not working for me.
This is Mr. Hanson, correct? Okay.
Did you say you have to be somewhere at 3?
I used to have to be somewhere.
Okay.
There was this excuse would be as good as any for not attending. This is an investiture for the new probate judge in Union
Oh,
County,
yeah.
which is Mr. Milks'
I was gonna
wife.
say, yeah. Mhm.
But this is more important.
Have you been here all day too?
You bet I
Yeah.
have.
It's been a busy day.
Yeah.
It has been a visit.
Yeah, we got one more.
We had a few today.
Do you have a run?
Yeah.
I only had 2 run, which is okay.
Stage had one run, so I had a bit of a break.
That's, yeah. That's usually great.
We didn't finish those. Those are
Nope. Yep.
extended.
Yeah.
So-
We finished very few. It
We
just
didn't-
feels like-
We started a lot. We didn't finish a lot today.
Incompleteness today.
Oh, that's a,
Tice got started.
Yep. was it officers not shown or?
So Tice is the directional one.
Oh, gotcha.
Yeah, and then one is like the jail calls got messed up when they got saved and didn't transfer over right. I guess, they got like UIT stuff and it, I don't know.
Oh, we're supposed to get a training on that. Did you see that email about the jail hall stuff?
I did, I wasn't sure, is that like they're gonna have a new system?
It's definitely like a day that I'm in court, so.
And then
Great.
Sage, their briefing and issue on Lake Shield. And
Oh,
then
interesting.
I started one and I have to brief an issue.
What do you, on what?
Good day, Judge.
You too, Mr. Austin. Thank you.
But no, defense stepped in for the assist.
So, did you want me to answer Ms. Bizzardi and tell her she still needs to appear tomorrow?
Yes. You get a chance.
I'm just gonna answer her email.
Appearance by Zoom is acceptable.
You got it.
She keeps telling me she can't because of
somebody
medical
else.
condition.
Well, then we'll deal with that.
Yes.
But she's up at 11:05 tonight, and she called the office.
Your parents by Zoom will be accepted. Yeah, exactly what you
She will
said.
need to appear via Zoom tomorrow. That's
That was one of my officers on a, that was a continuance. Right. It was the day that she had the funeral, so she took off and then two.
Oh, yeah.
And so the two officers.
I don't understand what
You don't get to adjourn the hearing based on your ADA.
that had nothing to do.
He's a pretty like.
I mean,
quiet
you
guy.
got that accommodation by you. Her PTSD. But she has no medical diagnosis.
No, I was like, no, we're not doing that. And then he's like, hey.
Nobody, she's struggling, but there's no doctor.
Okay.
Yeah.
Yeah.
Having her items on site.
Like, I don't.
Actually.
That's.
Yeah.
Yeah. So, but okay.
So, that's a-
Yeah, I have a lot of opinions about a lot of things today, none of them are positive.
All right, so we're on the record in docket 23-02903. That is people of the state of Michigan versus Joshua Hanson. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanchi.
Assistant Public Defender Melanie Wanchi for Mr. Hanson, who's City County Council.
Thank you. And sir, you are Joshua Hanson, is that correct?
Yes.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that we're going to be proceeding with the exam today.
All right. So is there any, we're gonna put the sequestration order in. I'll leave it to both counsel who know the case better than I do, that anybody who comes in and should not be in the courtroom watching another witness testify, bring it to my attention and I will invoke the sequestration order and make sure that they are not in the courtroom watching another witness testify. Are there any preliminary matters, any other preliminary matters? Ms. Wilson,
Not from the people.
Ms. Wanchi.
Nothing, Your Honor, thank you.
All right, you may call your first witness, Ms. Wilson.
Thank you. The people would call Officer Troy Brooks. Oh.
All right, Officer Brooks, we'll have you come up and you'll stand right in front of me and you'll indicate your first name, last name, and spell them both for the record.
Tory Brooks, Toribrooks.
Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, go ahead and have a seat. The microphone is for recording, so please talk into the microphone and project to the back as best you can. Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Brooks, where do you work?
Lansing Police Department.
And what are your general duties?
I am day shift patrol.
Okay. Now, were you working as a police officer back on August 7th of 2023?
Correct.
Okay. How were you dressed?
In my full patrol uniform, just like I am right now.
And Your Honor, for the record, I just asked that it reflect that the uniform does have several designations of police on it.
Okay, without objection, the records may so reflect the officers in uniform.
Thank you. Now, on that day, Were you dispatched to 120 West Michigan Ave?
Correct.
Okay, and is that in Lansing?
Yes.
Ingham County?
Yes.
Michigan?
Correct.
Okay. And why were you dispatched on that date?
I was dispatched for a late assault report, and it came out that it ended up being a domestic assault report.
Okay, and did you in fact go to that location?
To 120?
Yes.
Correct.
And when you got there, what did you first observe?
I observed a female with a male accompanying her, a white female, white male, and she was trying to make a report about a assault that happened the night prior.
Okay, and what was her demeanor when you were meeting with her?
From what I can recall, I mean, some time had passed, so she seemed like she was okay, but had talked about really wanting to make a police report and was in fear.
Okay, and when you say some time had passed, did you get a feeling or an indication of how much time?
From what I can recall, she said it was late during the night prior, so maybe not even full 24 hours yet.
Okay. Now, did you obtain any information about her relationship with her alleged assailant?
Yes, she said it was her boyfriend of approximately 3 years.
Okay. Now, without telling me what she said, did the victim describe or explain why she was making the report?
Correct.
Okay. And this incident that she described, was it at that 120 West Michigan Ave location?
So the actual assault did not happen at that location, but yes, when she was making the report, yes, she came into our police station, which is that address.
Okay, and did she indicate where the assault occurred?
Yes, I can't remember the numbers because obviously the time that had passed, but yes, I remember she gave me a different address that I.
To the best of your recollection, was that addressed in Lansing?
Yes.
Ingham County?
Yes.
Michigan?
Yes.
Okay. Your Honor, at this time, the people are going to request that we seek the admission of the statements that the victim made to Officer Brooks pursuant to MCL 768.27C. While I understand that there was a bit of a delay in the disclosure, the statute does indicate that it doesn't have to be immediate, just within a reasonable amount of time.
Thank you. Ms. Wanji, any response to the motion to omit domestic violence victim statements under 768.27C?
Yes, John, I will check. The alleged assault did not happen right away. It took a little bit of the time. The officers explained that it was maybe not less than 24 hours, but it was not even at that location.
All right. Based on what I've heard the officer testify to, the foundation for the 768.27C is evidence of a statement by declarant relating to infliction or threat of physical injury is admissible if the statement purports to narrate, describe, or explain the infliction or threat physical injury upon the declarant. The action in which the evidence is offered is an offense involving domestic violence. The statement was made at or near the time of the infliction or threat of physical evidence. Evidence of a statement made more than 5 years before the filing of the current action is inadmissible. This is much less than 5 years. We're within 24 hours. And the statement was made to a law enforcement officers. I make the decision to allow the domestic violence statements to come in based on the circumstances provided in these factors that are weighed, whether the statement was made in contemplation or pending of anticipated litigation, which does not seem to be the point, whether the declarant has bias or motive for fabricating the statement, and whether the statement is corroborated by other evidence is still out for further testimony. But I do believe that the foundation's been laid under 768.27C for the minimum amounts for hearsay statements to come in through the officer. And so at this time, you may ask your questions pursuant to that statute.
Thank you, Your Honor. Now, Officer Brooks, I don't think I touched on this, but did you learn the identification or the ID of the person that you were taking the report from?
Yes, the victim.
What was her name?
I think her first name, I believe, is Dorothy. I don't remember her last name.
Okay. Now
I can't remember what her.
That's okay. Did she say what happened?
She said that she got in an assault the night prior with her boyfriend.
Okay, and what did she say the assault was?
She said that she was sleeping on the couch and that her boyfriend came upstairs, pulled her by the hair, and was upset because he thought that she had been cheating on him, and left I believe, used cigarette in the toilet. And this sparked just an argument that continued throughout the night until like the early morning hours.
Okay, and when he pulled her by the hair, was that the only time that he touched her that evening?
No.
What else happened?
According to her, she said that he pulled her hair several more times through the night. At one point, he tried kicking her out of the house, like physically grabbing onto her, putting her out of the front door of the house. Every time she would try to leave, he would then pull her and bring her back in by the hair. She said this happened, I can't remember the exact amount of times, but several times. And that at one point, he had held a knife to her throat and actually cut her, but held the knife to her throat and basically said, if you try to leave or if you call the police, I'm gonna kill you and nobody's gonna find your body.
Okay. And did the victim indicate why she made a report later?
Yes, she was able to then finally leave and she wanted to be away from her boyfriend at the time, because she was in fear that he was actually going to do harm to her. So she was trying to create distance away from him before she could make a police report.
Okay. And did she say why she didn't call the police at that time?
She thought that she thought that he could potentially seriously harm her and she was in fear for her life.
Okay. All right, at this time, I have no further questions, Your Honor.
Did she ever?
Wait, sorry, I
Go
do. Did she give any sort of name or anything of her assailant?
Yes, Joshua
Okay, do you remember his last name?
Hansen.
Okay, and did she give you like a birth date?
Yes, she did. I don't remember the birthday off the top of my head, but yes, I know
Okay.
that the birthday and everything was on the body camera and I wrote it down in the
Okay,
report.
and at that time, did you, or anytime after, did you use that information to conduct a lien search?
Yes.
And did anything return?
Yes.
And was there a photo with that?
From what I can recall, yes.
Okay, and do you see a person matching that photo in the courtroom here today?
Yes.
Can you point him out and describe something he's wearing?
In white male over there in the blue jumpsuit glasses.
Your Honor, for the record, I'd request that I reflect identification.
Any objection to the witness identifying the defendant, Ms. Wanji?
Yes, Your Honor. I have some questions for her before.
All right, so subject to cross-examination for the court's purposes, the witness has identified the defendant and will allow any objection to be part of cross-examination. Ms. Wilson, you may proceed.
Thank you, Your Honor. Now I'm done.
Right, cross-examination, Ms. Wanji.
Thank you, Your Honor. Officer Booth, what name did you say the name of the victim was?
I said I thought it was Dorothy, but I could be 100% incorrect because this was in August and this is not my only case going today. But
Okay.
yes.
All right. And you did not see any picture of my client at home, correct?
I didn't see any picture.
Yes. She did not show you any picture of this gentleman.
Not that I can recall, but I saw a picture based on what I can look up.
Okay, I understand that. But when you were there, you did not see any picture of my client.
Nope.
You by his name only, you could not identify him.
No, from when I was talking to her, no. I had to look up afterward.
Okay.
Yep.
And you also testified that when, as you recall, when you got there, she seemed okay. She seems okay.
Yeah, so I said she seemed okay and that obviously some time had passed, but she expressed that she was in fear. Yes.
Okay. And you did not observe any knife at that time, correct?
No.
Yeah. I have no further questions, Your Honor.
Redirect, Ms. Wilson.
No, Your Honor, thank you.
May this witness be excused from the people.
She may, Your Honor.
Ms. Wanji?
Yes, Your Honor.
All right, you're excused. Thank you for your
Thank
appearance
you.
today. Any further proofs today, Ms. Wilson?
No, Your Honor, people would rest.
Motion for binding.
Thank you, Your Honor. First, the defendant has been charged with felonious assault. You heard here today from Officer Brooks that at a location, she couldn't remember the exact location, but she knew it was in Lansing, Ingham County, Michigan, that the defendant did hold a knife to his girlfriend's throat. She expressed to the officer that she was in fear for her life. A knife is obviously a weapon that could be used to inflict great bodily harm or even death. And the fact that he held it to her throat clearly indicates that he could have used it at that time. And he also made statements allegedly that he could use it. So I think the elements for felonious assault have been met. As to the interference with electronic communications charge, I understand that there has been no testimony here today as to that charge. So I think at this time, we would just dismiss that charge. And then the other counts in the complaint, I believe, are misdemeanors, and we would just request that they follow the felonious assault.
Thank you. Ms. Wanji, response to motion for bind over.
Yes, Your Honor. Like we said, the officer could not identify my client at the time. She did not ask to see the knife or even go to the place where the alleged assault took place. She did not recognize, she did not recall where the alleged address where the alleged assault took place. And so I don't think that there are all the elements of aggravated or the felonious assault at this time. Plus there was no injury, or she did not testify about any injury. She testified actually that the person was okay. And so we don't believe that there is enough here to bind the case over at this time, Your Honor. Thank you.
Thank you. So the standard for preliminary examination is probable cause. The people would have to prove by probable cause evidence, location, offense, venue, ID, and date. The date and venue, the city of Lansing being the venue, as indicated per the victim's statement. And the date of August 6, 2023, I believe been proven by Officer Tory Brick's testimony. So location, venue, and date have been indicated. Identification was made through the statements made from hearsay statements of the victim. And then the officer ran based on those victim statements, lean indicating that and getting a picture of Joshua Hansen, and then as a defendant and IDing him in court. I believe identification's been made. The only thing left are the elements of the offense. I believe in count one has been proven by probable cause evidence based on hearsay statements of the victim that the defendant did make an assault upon the victim in the case. She indicated she didn't remember the name, or she indicated that it was Dorothy. The allegation is Deborah Ware, the girlfriend with a dangerous weapon, a knife, but without intending to commit the crime of murder. Seems like there was an indication that a knife was held to a throat, and that's sufficient for probable cause circumstances for count one to be bound over. Count two is dismissed pursuant to the prosecutor's motion for bind over. There's been no testimony concerning any electronic device being maliciously prevented, obstructed, or delayed. So count two is to be dismissed. Counts 3 and 4 are misdemeanors, and they will follow count 1 to circuit court. So the court will bind over as charged on count 1, dismiss count 2, and counts 3 and 4, the misdemeanor counts, are now will follow as misdemeanors to count 1. So, Mr. Hansen, please keep in contact with your attorney, Ms. Wanji. Your time in district court is done, and so you'll be on to circuit court for count 1 and the ride-along counts 3 and 4. Anything else for the record in docket 2302903, Ms. Wilson?
Not from the people.
Ms. Wanji.
Yes, you have like to address bond.
You may.
It is my understanding that my client not able to post bond at this time. I don't have any report that he tried to appear in court when requested to do so. The alleged victim is not even here, so I don't know. I think that there is also any report that he violated the no contact order when he was in jail. We don't know. And so I will ask the court to allow him to go back home and to post bond in a PR bond at this time, Your Honor, because the amount of money that he have, what if it is not, the bond at this time amount to a no bond because he's indigent and there is no flight to this. Thank you.
My understanding is bond was set by Judge Ward at $7,500. Is that correct, Ms. Wilson?
That's what it appears.
All right,
yes.
response?
Thank you, Your Honor. Given the nature of the allegations, I think bond is appropriate in this matter. And I will also add that I don't know the reason why, but it appears that Eaton County does have a hold on Mr. Hansen as well, in the amount of $1,824.
I'm gonna leave bond as the same, was set by the judge in the matter, Judge Ward. I did dismiss, count 2 was dismissed as the electronic device. Count 1, which is the felonious assault, has still been bound over. So I'll leave bond. It can be readdressed in circuit court, but the reduction of bond is denied, and it'll stay at 7,500 cash assured. Anything else for 23-02903, Ms. Wilson?
Nothing from the people.
Ms. Wanji?
Nothing, Your Honor.
All right. Your next date will come from Ms. Wanji in circuit court. Thank you for your appearance today. I think that's it. I'm afraid to say so. I'm afraid to say anything that change that. That I evidently I have the power to change things I don't understand. So, but I think that's it. So, Ms. Wilson, we will see you tomorrow.
Yes.
For probable cause,
It'll be a
but
shorter
you
day.
definitely deserve a timeout day today. There was a lot of witnesses. Yep. Absolutely.
When do you have the transcript request?
Thank you.
Thanks.
Ms. Wanji, you're all set?
Yes.
All right, thank you for your appearance.
Thank you.
Oh, man. You did it though.
I did it.
You got it.
Well, I don't think anything got outright dismissed, so. Take it a win.
I think tomorrow's kind of a little bit of everything
Yeah.
on our docket. Restitution tomorrow?
No, that's next.
For
Okay.
Hun? No, dear God, no, I hope not.
Dear God, no. I think that said it all right.
Yeah.
I'm with Abby. Dear God, no. Oh my God.
We set aside some time for that.
Yes, we did, yep.